Hey, good morning, everybody.
Good morning.
All right, so we got Mr. Peterson, got Maria.
So for the witness, I'm assuming that we're going to interchange using this one computer. So I don't know how you guys want me to change the name or don't change the name and just leave it as witness. Because we're going to be sharing one.
I think you can just leave it as witness.
Sounds good.
Okay. So we're just waiting on one more judge. And then we got one competitor trying to connect. I think I'm missing a competitor. Maria, you good? I can't hear you for some reason. Here, unmute yourself and let's see if we can hear you. No, I can't hear nothing from you. Yeah, well, I mean, honestly, I don't know that we necessarily need to hear you except for comments. So, I mean, it's up to you. If you want to monkey with it, feel free. Your hand gestures will suffice. All right, so it looks like I've got everybody in the room. Just one real quick check. We've got Lauren Duig, we've got Aaron Friedman, Ryan Nacino. Do we have Aaron Freeman? Lauren, is he on?
He should be. He was the one who sent me the link. So there may have been a technical difficulty.
He's there. He's called Friedman. And then we've got Nicole, the second chair, and we've got our witnesses, and all the judges are here. And then Judge McIntyre, whenever you get a minute, turn your camera off and we'll get this party rolling. Get my timer. Okay. Let me see. Okay, so y'all have got 5 minutes for pretrial. I guess I'll call the case. So now calling the case of Jordan Gilmore versus Chimes Department Store Inc. Ready for trial. Counsel for plaintiff ready?
Yes, Your Honor.
And defense?
Yes, Your Honor, we're ready.
Awesome. Okay. Y'all got 5 minutes apiece for pretrial if you got anything that you want to take up. So we'll start with plaintiff.
Yes, Your Honor. Before we get to procedural matters, permission to make appearances before the court.
Oh, yeah.
Good morning, Your Honor. My name is Lauren Doig. It's pronounced Doig, but I'll answer to anything close, Your Honor.
I'll say it right. I'm sorry about that.
No worries. And I'm here with my second chair, Mr. Aaron Friedman.
Hi, guys.
Morning, Your Honor.
Good morning.
We do just have two procedural matters once opposing counsels had the chance to introduce themselves.
Mr. Nacino, you want to introduce yourself and co-counsel?
Yes, Your Honor. Good morning. My name is Ryan Nacino, appearing on behalf of Chimes Department Store. And today I'm joined by counsel.
Good morning, Your Honor. Nicole Furlani for the defendant.
All right. All right, Ms. Duig, your procedural stuff, whenever you're ready.
Yes, Your Honor. Just to, Your Honor, it's a hard one. So anything is close enough. Your Honor, just as far as exhibits go, we spoke to opposing counsel before trial, and we were able to stipulate to the admissibility of 4 exhibits. Those are exhibits 2, 3, 6, and 14.
3, 6, 14. Okay, awesome.
And we would also like Your Honor's permission to show 2 of those exhibits, exhibits 2 and exhibits 3, in my opening statement. If Your Honor's okay with that, we already spoke to opposing counsel and they had no objection.
As long as the opposing counsel is fine with that, I'm fine with that.
Your Honor, we had no objection to that. We actually wanted to show 3 of those exhibits in our opening statement.
Perfect.
With that, Your Honor, the plaintiff is ready to begin.
All right. Let's hear from anything from you, Mr. Nacino.
Yes, Your Honor. A couple of housekeeping matters and then 2 stipulations we want to put on the record.
Sure.
First, it's our understanding that Your Honor has an electronic copy of the case materials. We just want to confirm that before we start getting into the weeds on anything.
I should. Let me make sure that I've got it ready to go. Yeah, I've got it.
Great, Your Honor. All exhibits in this case have been pre-marked as joint exhibits. I think we might have just done it actually, but for convenience of court and counsel, we ask that all exhibits retain those markings regardless of the order in which they're admitted.
Okay, but if when y'all are showing them, y'all are going to take care of putting them on the screen and all that, right? With your second chair, is that correct?
We're going to do that, Your Honor. Yes.
Excellent.
When we do that, would you like us to ask permission before we do it each time, or are we okay to just put
In
it
the
on?
open, no, I mean in the opening statements, just make sure it's admitted, before you show anything. But yeah, I mean y'all operate seamlessly. No need to ask me.
Understood, Your Honor. Last request, we request that all that all objection arguments be heard constructively at sidebar, meaning that we'll assume that the jury isn't present for those objection arguments.
That's absolutely fair.
No other housekeeping matters, Your Honor. We do have 2 substantive stipulations to put onto the record.
Okay. Well,
And we think they would benefit from a brief factual background if you're willing to hear it.
okay. Yeah, I mean, I guess we can do that in pretrial. You've got 3 minutes, so let's make it quick. Can you get it done then?
I'll make it quick, Your Honor. I promise.
Go ahead.
On January 23rd, 2019, the plaintiff was walking up the steps of the loading dock at Chimes Department Store. But when he got to the top, he saw that the door was swung open and was blocking his path to get inside. instead of opening or closing the door so he could step up.
Why don't we save this for opening statement? This sounds like something for opening statement, not a pretrial, sort of preferential or procedural matter. Let's save it for when we're actually, starting things. So does that sound fine?
Certainly, Your Honor.
Okay, let's do it that way. All right. So Ms. Doig, whenever you are ready.
Your Honor, we do have two stipulations to put on the record still.
Okay, go ahead. What are those stipulations?
We spoke with plaintiff's counsel. The parties have agreed exhibits 8 and 9 will be precluded. There are photographs of the plaintiff's knee following a surgery for the injury sustained in the accident that he's filed a claim for.
Okay, very good.
And the second is the parties have agreed to not mention a subsequent remedial measure that was done by Chimes Department Store installing a light switch out back for the loading dock. One of the claims the plaintiff has made is that there was insufficient lighting in the back loading dock. They've agreed they're not going to elicit any evidence or argument about that subsequent remedial measure of adding a new light switch.
Okay.
Your Honor, I'm sorry, Your Honor, if I could just clarify for the record, we
Sure.
did speak to opposing counsel and we agreed that we will not be eliciting that testimony under 407 unless one of the exceptions come up today, whether there's a dispute of ownership or a dispute in feasibility. Opposing counsel let us know that they won't be disputing that, so we don't plan to get into that evidence, but I just wanted to make sure that Your Honor was aware that we did say if that door was open and we need to address it, we do plan to do so.
Of course. All right. Just one real quick thing. Judge Walraven, did you need something or can you turn your camera?
I did. Before you get into opening statements, can you send out your cell in the chat in case we have any technical?
Absolutely. Thank you for reminding me of that.
Thank you.
And you reminded me in the chat and I just can't read nothing. Sorry about that. All right. Yeah, here's my chat. Here's my number to everyone. All righty. Okay. With that in mind, does that conclude everybody's pretrial matters?
We're ready for opening statements, Your Honor.
Okay. All right, the court now recognizes plaintiff for their opening statement.
Yes, Your Honor. On January 23rd, 2019, Jordan Gilmore reported to work like he always did. He was a loyal employee of the Chimes Department Store, right here in Lone Star, where he'd been working as a cashier for 10 years. It's been a busy day at the store, and after a couple of hours of working that evening shift that Thursday, Mr. Gilmore needs a break. He needs a cigarette. He remembers that he just got a harsh reminder from his boss at Chimes Department Store that cigarettes, they weren't permitted out front, where he may be seen by customers. So if he knew that if he wanted to smoke, he had to do it where his boss told him to, the back stairwell. This is that back stairwell. Only it didn't look like this that evening. You see, it was cold and it was windy out. It was past 7 p.m. when Mr. Gilmore took his break, which meant here in Lone Star that it was pitch black outside. So dark that Mr. Gilmore actually had to grip onto the wall, step by step, as he climbed down those stairs, because there was so much loose concrete he couldn't see. Holding the wall, he makes it to the bottom of the stairs, pulls out a pack of cigarettes. After a smoke or two, he gets so cold that he's ready to go back inside. His coworker holds the door inside to provide a little light to help guide his path. But when he did that, it also meant that part of the platform on the top, as you can see, was blocked. In the dark, Mr. Gilmore walks, hand on the wall again, and tries to put his right foot on the top step, where there's a sliver of light. But as he puts his foot down, he feels his foot slip. He knows what this means. His heart starts racing, and he reaches out to try to grab onto something. There's no handrail. He even reaches for his coworker, but it's too late. Nothing left to grab onto. Mr. Gilmore falls backwards. And as he's falling, he knows what's going to happen. So he jumps to try to stop his fall. and ends up crashing on the ground, leading to permanent and severe leg injuries that put him out of work, required surgery, and brought us here today. Unfortunately, for Mr. Gilmore, he couldn't stop himself from falling. But there's someone who could, and that's the defendant, which is exactly why Mr. Gilmore filed today's lawsuit against the defendant, Chimes Department Store, for failing to protect him from a danger that they knew, a danger that they created, a danger that they could have and should have fixed. Ladies and gentlemen, I want you to meet Mr. Gilmore. Mr. Gilmore, could you please turn your video on? Members of the jury, this is Jordan Gilmore. Mr. Gilmore was the defendant's prior employee of 10 years who expected the defendant to keep him safe at his job. But as you'll learn, this was far from the case. Now, as the plaintiff, we have the burden of proof in today's case. All that we need to show you today is that it's more likely than not that the defendant was negligent. We will do that today, because you'll learn that the defendant knew that those back stairs were dangerous. And the defendant knew that all it would have taken to make them safe was three things: a light switch, repaired concrete, and a handrail. You'll hear a lot about those three things today. Quick and easy fixes to protect employees like Jordan Gilmore. Not only are those fixes quick and easy, you'll actually learn that they're required by law. There are laws that require employers like the defendant to provide a safe working place. There are rules and regulations that every employer must follow. Rules to keep them safe. Rules about lighting, rules about concrete, and rules about handrails. Rules that had the defendant followed, we wouldn't be here today. Now, today the defendant has filed what's called an affirmative defense. And what that means is that they're here today pointing the finger at Mr. Gilmore, their employee of 10 years, who they directed down their own stairs, saying that he is to blame for his own injuries. Every time the defendant comes up here today and they point the finger at Mr. Gilmore, I want you to keep in mind what the defendant knew. Because the defendant knew those stairs needed a light, they needed repaired concrete, and they needed a handrail. And the defendant knew that without those three things, those back steps were a disaster waiting to happen. Instead of preventing their employees from entering that danger zone, they required it. They ordered employees to use those stairs to take a break, smoke a cigarette, to take out the trash, day after day after day. We're not here today because of a freak accident or an unlucky coincidence. This was a preventable injury that only happened because a department store whose responsibility was to keep their employees safe failed. Which is why at the end of today's trial, I'm going to come before you again and ask you to tell the defendant that employees deserve more than that. Mr. Gilmore deserved more than that, especially when all it would take is a light switch, repaired concrete, and a handrail. I'll ask you to tell the defendant that by finding them liable.
Okay, so 47 remaining for plaintiff. Okay, defense, whenever you're ready, I'll start timing.
Yes, Your Honor. May it please the court. This fall, it wasn't their fault. It's a cold night in January. A tired employee is finishing a cigarette. He brings it to his lips. His fingers are quivering. His cheeks are red. The wind is whipping against his face. He's shivering. So he takes one last drag, throws it away, and turns to walk back inside. But separating him from the warm interior of the department store is 5 steps leading up to a loading dock. And there's a door swung slightly open, blocking the steps, blocking almost the entirety of the top step, leaving just a tiny piece of concrete. The employee, he doesn't reach up and pull that door open so he can walk up the steps easily. He doesn't do the normal thing. Instead, he does the faster thing. He takes his right foot, puts it on that top step, the tiny piece of concrete that the door isn't covering. He swings his left leg around the steps and tries to sneak his body past the door and back inside. Members of the jury, today you're going to learn that the faster thing, it wasn't the safer thing. Because you'll learn that that employee, the plaintiff, he didn't sneak around that door and get back inside. He slipped, fell backwards, and landed on the concrete. Today, it will be undisputed that in the 10 years the plaintiff had worked at that loading dock, he had gone up and down those steps literally thousands of times. Never once slipped, never once stumbled, never once fell. The evidence will show that the only difference in this case was that the plaintiff was rushing. Today, the plaintiff is going to say it's not his fault that he fell. He's going to try and blame Chime's department store. It was their loading dock that he fell off. Today, you'll learn that Chime's, they're a Waco institution, a family business, been here for generations. Mr. Geller, can you turn your camera on for us? This is Reese Geller. A couple decades ago, his grandma and grandpa, they opened a store that they called Chime's. These days, Mr. Geller, he's followed in the footsteps of his parents and grandparents. He's the owner of Chime's. Thank you, Reese. You can turn your camera off. Now, today it's the plaintiff's burden to prove more likely than not, by a preponderance of the evidence, that there was an unreasonably dangerous condition on Chime's property, that they should have known about it, and that they failed to act like a reasonable company to fix it. Today, the plaintiff isn't going to be able to meet that burden. And that's because the evidence is going to show that Chime's, they were safe. But there's going to be a second separate reason that we're going to ask you to find for the defense. We've raised what's called an affirmative defense. And on this, we have the burden of proof. We have the burden to prove that the plaintiff fell off of that loading dock because of his own carelessness. Today, we're going to meet our burden by proving 2 facts. That this fall, it wasn't Chime's fault. And this fall was the plaintiff's fault. Let's take them one at a time. Fact one. This fall, it wasn't Chime's fault. This is the loading dock behind Chime's department store. It's a little more than 2 feet off the ground. Today, it's the plaintiff's burden to prove that this loading dock was an unreasonably dangerous condition. And I want to say that one more time because it's really important. The plaintiff has the burden to prove more likely than not that this 2-foot loading dock was unreasonably dangerous. Today, you're going to hear that Chimes, they'd been using that loading dock for 15 years. And in all those 15 years, there was only one person who ever so much as slipped on those steps. Just a moment ago in their opening statement, plaintiff told you that, well, Chimes, they knew it was dangerous. They knew they had a problem. But what you're going to hear is that in 2018, not long before this accident, an inspector from OSHA came to Chimes, an inspector with a decade of experience. And he inspected Chimes's property thoroughly. He didn't find any problems. They didn't find any dangerous conditions. They didn't write any citations. Plaintiff just told you it was going to be 3 things: the lighting, the concrete, and the rail. You're going to hear that inspector from OSHA didn't have a problem with any of those 3 things. Today, the only witness who's going to tell you there's a problem with any of those 3 things, that they violated any regulation, is a professional expert hired and paid for by the plaintiff. Brings us to the second fact. It's going to help us prove our burden. This fall, it was the plaintiff's fault. Today, you're going to see what the loading dock at Chimes look like on a normal day. Door wide open. Lots of space on these steps to put your foot and walk up. But what you're going to see is that the night of January 23rd, 2019, that cold, frigid night, this is what the plaintiff saw. Narrow set of steps. Not a lot of space to walk up. You're going to hear today that the plaintiff, he could have pulled this door open to make it easier to walk through. Before today's trial, we actually had a chance to depose the plaintiff under oath. And we asked him, why didn't you just open the door? His answer? I was cold. And I wanted to get inside. Members of the jury, today we're not going to deny. Chimes, they could have had more lights. They could have had a railing. They could have done a number of things. But that doesn't mean that they were negligent. See, Chimes, they thought that their employees were going to be careful, that they would do the obvious thing, open the door so they could walk by, instead of the fast thing like the plaintiff did. And we want to be clear. We're not saying that the plaintiff deserved what happened to him. We're not saying he's a bad person or a bad guy. But the evidence is going to show on that night, he made a bad choice. Because he made that bad choice, the evidence is going to show that this fall, it wasn't Chimes' fault. So at the end of this trial, we'll ask you to return a verdict for the defense. Thank you.
Okay, 4511 remaining for the defense. Okay, let's see. 47. Plaintiff, you may call your first witness.
Yes, Your Honor. The plaintiff calls Jordan Gilmore.
Can you hear me?
Yes, and the witness has been previously sworn.
Perfect. May I begin, Your Honor?
You may.
Good morning, Mr. Gilmore. Please introduce yourself to the jury.
So my name is Jordan Gilmore.
Where do you live?
I live in Waco, Texas.
How old are you?
I am 48 years old.
Mr. Gilmore, are you married?
I am not.
Do you have any children?
No, but I have some cats that I consider them my children, and a couple plants I take care of as well.
Do you currently work?
I do not.
Did you ever?
Yes,
Where did you work?
I was a cashier at Chimes department store.
How long did you work at Chimes department store?
I was there for 10 years, over a decade.
You said you were there for over a decade, but you don't work now. Why not?
Well, I got injured and I had to leave the job because I couldn't do the cashier job that was required with my injury. And by the time that I was coming back, the position had already been filled.
So you said you were injured. Where were you injured, Mr. Gilmore?
I was injured at Chimes department store.
Where at Chimes department store?
On the back, there's a loading dock area that I fell at.
I want to take a closer look at that loading dock area. Your Honor, permission to publish exhibits 2 and 3. These are two of the exhibits that we stipulated to with opposing counsel. Mr. Gilmore, I'm publishing exhibit 2. Can you explain to the jury what we're looking at here?
So this is the loading dock that I was talking about where the accident occurred. Right behind those doors is the Chimes department store. And we come out here to smoke.
And I see there's something to the left, or it might be to the right on your screen. What is that object?
Yeah, that's the dumpster. That's where we take out the trash.
Would you also use these stairs to take out the trash?
Yeah, well, we use the stairs for any time we come out there. So to take out the trash, to dispose of any boxes, to take a smoke break, we go up and down those stairs pretty consistently.
Mr. Gilmore, when you're going up and down those stairs consistently, like you say, are there any safety measures that you've observed on these stairs?
By safety measures, like a handrail or anything, there's not, but there's these two pipes where there used to be, I assume there used to be a guardrail. But other than that, not really, but sometimes I put my hand up against the wall to like walk up the stairs.
And you said there's not a handrail, but you still put your hand against the wall. What were the condition of the stairs themselves?
Well, the stairs, they're old, like as you can see in the picture, they're old, they're crumbly. It's concrete that is very hard to, like, grainy, just breaks apart.
I want to zoom in on that concrete. Your Honor, permission to publish exhibit 3. So looking now at exhibit 3, what are we looking at here?
So this is just the steps from this point of view. That's the door that is now swung open. Those are the two pipes that I was talking about that seem to be removed. And then as you can see in those zoom pictures, like that's the crumbly concrete that I was talking about, that they're just old and beaten.
So these two pictures we just looked at, exhibits 2 and 3, did the back of the defendant's store look like this the night you fell?
Well, yes, but not exactly, because it was at night. So it would have been very dark.
What time was it?
It was about 7 o'clock. In January, though, the sun goes down about 5 or 6. So it would have been pitch black.
So it's pitch black outside in Waco around 6 or 7. Were there any lights outside on these stairs?
Well, there is that light where the circle's at in this picture, but it wasn't on.
Why wasn't it on?
So that light the switch, I'm actually not sure if it even works. I've never seen it on personally, but the switch is on the other store, which is a Home Depot. That's where the light switch to actually turn it on is at.
So you said you were walking down here in the dark. Did you ever tell the defendant about that?
Yes, I mean, we mentioned it multiple times to the manager. And just in general, we've mentioned it to the supervisors that work there.
And how did these supervisors and managers at Chimes, how did they respond?
Well, they've always said that they think that it would be, they think it's something that they should get fixed, but it's not exactly on the top of the priorities list.
Now, I want to talk to you about the night of your fall. Who are you with?
So I was with a coworker, Riley, and yeah, that's who I was with, Riley.
So you were with Riley and you went to the back stairwell, and what did you do?
So we went down the stairs. We were on a smoke break actually, and we just went down to like a regular smoke break. You just go down there and take the smoke break.
And why were you back there for your smoke break as opposed to the front entrance or anywhere else on the property?
Well, that's where they told us to go. There was a memo that came out that they told us that we should take our smoke breaks in the back in that area.
So you're taking your smoke break in the back in that area, and where's Riley at this point?
So she's at the top, holding the door open.
And why didn't you stay with her at the doorway?
Well, they don't like the smoke of the cigarettes coming into the store. Nobody likes the smell of cigarette smoke lingering. So you have to go all the way down so there's no smoke to go into the department store.
Did you go all the way down as you were instructed?
Yes, I did.
Did you smoke a cigarette?
Yes, I did.
And then what did you do?
So after that, I proceeded to head up to get back to my job. The smoke breaks are usually like 5 minutes. So after that, it's right back to work.
And you said earlier that when you walked down, you had your hand against the wall and were walking down carefully. Were you doing the same thing on your way up?
Yes, I was. So I was walking up the stairs just carefully because it's dark. And I was walking up, and as I got to the last step, that's when the accident happened because the way the door was propped open.
So you were here for no opening statements, and you heard the defense say in their opening statement that you were rushing to get upstairs. Were you running to get up those stairs?
No, I was just walking.
Were you Spider-Manning around the door to get inside?
No, I wasn't.
How were you walking up those stairs?
So I was just normally walking with my hand on the wall, and I had to let go of it, obviously, to go around the door. And I do this all the time. But when I stepped on that last step, I'm assuming the concrete is what caused me to slip.
And when you slipped on that concrete, how did you react?
So I mean, it's natural occurrence what a person would do, that you try to prevent yourself from, causing any sort of damage. So I jumped back and tried to land on my feet, but I landed, the floor is unlevel where I landed, and most of my weight went on my right side, and then I fell back onto my butt.
Mr. Gilmore, after you sustained that injury, after you fell, did you talk to the defendant's manager?
Oh, absolutely. You always have to file. Anytime that there's an accident, we file an accident report.
When you're filing that accident report, what did the defendant's manager say to you?
They said they were sorry. She did apologize, I remember. And
did she say anything about fixing the lights?
oh, yes. She said that it was something that should have been fixed. But again, nothing, just, I guess, not a top priority.
Now, you said that the defendant knew that that back stairwell area needed to be fixed. and you knew that the light wasn't working back there. So why exactly did you choose to go back there in the first place?
Well, that's where you have to go to smoke. You can't go to the front because, well, you'll be disciplined by the store policy is to go to the back. That's where the smoke break area is located.
You mentioned earlier in our discussion that you received a memo from one of your employees. Your Honor, I have that memo marked as Exhibit 1. May I direct the witness's attention to it?
Any objection?
No objection to this exhibit.
Absolutely.
If there's no objection, I was just going to lay the foundation, but if there's no objection, permission to publish?
Permission granted.
Mr. Gilmore, is this the memo that we were just talking about?
Yes.
And who wrote this?
So Lane Kim, our manager there at Chimes, wrote this.
I want to direct your attention to the first paragraph of the memo. Mr. Gilmore, could you read that for us?
Yes, it says, I'm sending you this memo to remind you that the owner does not want any employees taking smoke breaks in the front of the store. Apparently, the last time Reese came by the store, someone was smoking out front, and Reese is the owner there. So we can't have that, as you have been told before. If you're going to smoke, you need to smoke out behind the store where our dumpster is. That is the only place you should take smoke breaks on the premises.
Mr. Gilmore, in this memo, did they tell you, after directing you to use this black stairwell, what to do about the lack of lighting?
No, they didn't bring it up by any means.
Did they warn you about that they had no handrail back there?
Not at all.
Did they tell you to use a different area at night because of the uneven concrete?
Nope.
What did they tell you?
So the only thing they told me is that you make sure that you pick up the cigarette butts and keep the area clean and make sure it's presentable.
And after they sent you this memo, directing you to use those back stairwells, did anything about that stairwell change?
No, it stayed exactly the same.
Thank you, Mr. Gilmore. I pass the witness.
Okay, give me 1 sec just to reset the time. 35:42 remaining for plaintiff. And 45 minutes and 11 seconds whenever you start talking defense.
Yes, Your Honor. May I proceed?
You may.
Good morning, Mr. Gilmore. I just want to orient the jury on what happened to you during your accident. Ms. Furlani, can we get Exhibit 2 back on the screen? Now, like you told us, you and a coworker, you walked out of this door.
Yes.
That door, that's what Ms. Furlani is highlighting right now.
Yes.
Like you told us, you walked down those steps.
Yes.
And then when you were done, you walked back up.
Yes.
There was 5 steps leading back up to the loading dock.
Yes.
When you got up to the landing, the landing's the part that Ms. Furlani is highlighting now.
Yes.
When you got to the landing, that's when you slipped, right?
Yes.
Now, on direct examination, you said you assumed you slipped because of the loose concrete.
Yes.
Mr. Gilmore, it's true. You actually don't know why you lost your footing.
No, I do not.
What you do know is after you lost your footing, you fell
Yes.
down onto the concrete where Ms. Furlani is putting an arrow.
Yeah, it'd probably be a little bit more to the left of where the arrow's at, but that's roughly it.
About the area down here, right, Mr. Gilmore?
Yeah.
I want to talk about whether this area was actually all that dangerous. January 23rd, 2019, it wasn't the first time you used that loading dock.
No, it wasn't.
You'd been working for Chimes for 10 years at that point.
Yes.
You'd say that you use that loading dock about 20 times a week.
Yes.
20 times a week for 10 years. Mr. Gilmore, that's over 10,000 times you use that loading dock.
If you say so, I don't know if that's accurate, but
Mr. Gilmore, did you believe me that 20 times a week for 10 years, that's a little over 10,000 times?
Oh, yeah.
You use that loading dock in the daytime,
Yes,
in the nighttime,
yes,
when it was well lit,
yes,
when there weren't any lights.
yes. Well, the light from the door, we prop the door open like it was that day.
We'll talk about the light and propping the door open, Mr. Gilmore, but you use that loading dock when there weren't any other lights other than that door, right?
Yes,
You use that loading dock to take smoke breaks.
yes,
You use that loading dock to take trash to the dumpster.
yes.
In the 10 years you worked for Chimes, at no point did those steps have a railing.
No, they didn't.
And in the 10 years before January 23rd, not once did you slip.
No,
Not once did you stumble. Right, Mr. Gilmore?
yeah,
Not once did you fall.
no,
Not once did you get hurt.
yeah. Not once did I get hurt.
I want to talk about something you said on direct examination. You said that there weren't any lights on above the loading dock, right?
That's correct.
In those 10 years, those 10,000 times you use that loading dock, you actually don't remember the light above ever being on.
No, I don't.
I want to talk about whether this is actually Chime's fault that you fell off that loading dock. And I want to really break it down piece by piece. Like you told us, you and a coworker went out and your coworker was holding that door open for you.
Yeah,
He had it propped open.
yes,
I want to take another look at what that looked like. Ms. Furlani, can we get Exhibit 3 up on the screen? This is looking down those steps.
yes,
This is about where the door was when you were coming back up that night.
yeah,
This door, it's in the way of the steps.
yes, it is.
There's not a lot of space to get by that door on that top step.
No, there's not.
You'd agree it's pretty narrow.
Yes, I would agree.
I want to take a look at what you could have done going back up those steps. Ms. Furlani, can you put Exhibit 6 on the screen? It's one of those exhibits that was admitted pre-trial. And I want to see Exhibits 3 and 6. Yeah, you got them already for me, Nicole. Thank you. Mr. Gilmore, Exhibit 6, that's where the door is wide open, right?
Yes,
The door, it can open that far.
yes, you see it right there in the picture.
When the door is open that far, the steps, they aren't blocked.
They are not.
Now, you said on direct examination that the concrete on the steps was crumbling and it was falling away.
Yes, you can see it right there in that picture.
Well, we can see in Exhibit 6, Mr. Gilmore, that in the middle of the steps, concrete, it's all there.
I would agree.
When you were walking back up those steps on the night of January 23rd, you didn't swing that door open.
No, it was windy that day.
Well, we'll talk about why you didn't do it in a second. But coming back to my question, you didn't open that door anymore.
No, we didn't.
That coworker you were with, though, when she helped you get back inside the store, she did open that door all the way.
Yes, she did.
When she opened that door all the way, she didn't have any trouble getting up the steps.
I mean, I don't know if she had trouble or not. She was helping me out. You'd have to ask her that.
Well, you don't remember her stumbling.
No, she didn't stumble.
You don't remember her slipping.
No,
You don't remember her falling.
I do not.
And like you just said, it wasn't just her walking up the steps. Right?
Oh. Yeah, she was helping me out.
She was helping carry you up those steps.
Yes, she was.
Now, when you were coming back up these steps, you didn't open that door because, in your words, you were cold and you wanted to get back inside?
I don't remember if I said that.
Mr. Gilmore, is it your testimony that you didn't open that door for some other reason other than being cold and wanting to get back inside?
Well, I was cold and I was going to get back inside, but it was windy that day. So she was holding it so you can easily pull it back in to close it. So that's why it wasn't open all the way.
Mr. Gilmore, I want to make sure we're really clear. Is it your testimony that you didn't open that door because it was windy?
And I was in a hurry, so it's a combination of those things. It was windy, so we could pull the door back open, and then also I was in a hurry, so I just go around it.
Mr. Gilmore, you remember being deposed before
I do.
today's trial?
Yes,
Deposition, that's when lawyers ask you questions while you're under oath.
right.
When you were deposed, you swore to tell the truth.
Yes,
Swore to be complete.
yes,
You swore to be accurate.
yes.
I want to ask you to pull up that deposition. You have it available for you?
Let me see.
Take your time. Just let me know when you have it.
Okay, I have it.
Your Honor, we're going to mark this just for identification as Defense Exhibit A.
Very good.
Mr. Gilmore, the document you have up on your computer, that's your deposition?
Your Honor, could I have a point of order? Can I have a citation for what opposing counsel's getting into?
Sure, Your Honor. I'll ask the witness to go to a specific line, but I can give the citation now if plaintiff's counsel prefers.
Please.
It's on page 13 of the deposition, lines 5 to 9.
Your Honor, I would object to an improper impeachment then. This is exactly what the witness just said, that it was cold and it was windy and they were trying to get inside. There's no inconsistent statement.
Mr. Nacino, in response?
Well, Your Honor, the question that was posed was about why this witness didn't open that door. And if I can make an offer of proof, the answer is about what the other individual was doing, not about this witness. So there is an inconsistency here.
Your Honor, if it's about a different witness, then opposing counsel should ask this witness about a different witness, not impeach on what someone else might have done or might have said. That's not the question that was posed.
Yes, page what? Page 13. Time has stopped, by the way. Page 13.
Yes, Your Honor, page 13, lines 5 to 9. And the question, the part of the answer I think that Ms. Doig is pointing to is where Mr. Gilmore
Right.
says.
That's a different question than you asked, counsel. You were asking why he didn't open the door. It looks like the question here is why didn't you ask Riley to open the door? Right. So it would be understandable that those two things would be incongruous, right? Because those are two different questions.
Yes, Your Honor.
Okay, I'm going to go ahead and sustain that objection.
Understood. Mr. Gilmore, you can put your deposition aside for a moment.
Okay.
Now, when you were walking back up the steps, you didn't ask Riley to open that door any wider.
No, I didn't.
What you did instead is you put your right foot on the edge of the top step.
I don't remember if it was on the edge, but I would assume so.
Well, it was on the space that the door wasn't blocking.
Yes.
And when you did that, you tried to get by the small area that the door wasn't blocking.
Yes.
You slipped.
Yes.
You lost your balance.
Yeah.
You fell backwards.
Yes.
That is when you got hurt.
Yes.
Thank you, Mr. Gilmore. Pass the witness.
Okay, 3504 remaining for defense. Give me 1 second to get your time back up. Any redirect?
Nothing based on that, Your Honor. May the witness be excused?
The witness may be excused. Thank you for your time, Mr. Gilmore. All right. Plaintiff, you may call your next witness.
Yes, Your Honor. We're calling a witness by deposition, Your Honor. We did give opposing counsel a highlighted copy of everything that we're planning to read. However, they didn't want to discuss objections pre-trial. They wanted to do it before the court now. So before I read them, I just wanted to make sure with opposing counsel, they don't have any objections or anything they want to discuss, so it can be streamlined once we start reading.
Your Honor, we didn't have any objections to those portions.
Okay.
We do have one question and answer that we would like to read as a counter designation under Rule 106. We'll have Ms. Ferlani send that over to plaintiff's counsel now as well.
Okay.
Your Honor, permission to have my second chair, Mr. Friedman, read the answers while I read the questions?
Absolutely. Time will start whenever you begin.
Yes, Your Honor.
Okay.
Beginning on page 2 of the deposition, line 6. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Danes.
Tell us about your education.
I have a Bachelor's of Science in Mechanical Engineering from the University of Wisconsin-Madison.
Since graduating from college with your mechanical engineering degree, have you gotten any further education?
Sure. I've attended various seminars offered by the National Academy of Forensic Engineers. I took the courses to become a certified person/builder from the Scaffold Training Institute, and I took the requisite courses to become certified in ASME B31.3 process piping design from the American Society of Mechanical Engineers. So basically, some continuing education and additional certifications.
I noticed that your CV lists you as a PE. What is that?
It stands for Professional Engineer.
For court and counsel, we're now on page 8, line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
What is the basis for that opinion?
Well, in regards to the International Building Code, the city of Waco adopted that code and incorporated it into its own city ordinances on March 20, 2001. The OSHA regulations were enacted into law in 1970, so both the IBC and the OSHA regulations would apply to whoever was responsible for the maintenance and repair of the area where this incident occurred.
All right, so which portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which can be found in 29 USCS 654, and the maintenance provision under section 3401.2 of the IBC.
Why are those significant in this case?
These are general provisions that require an employer and or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here, as you can see from the photographs that I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant did not have such a program and never identified or corrected these hazards. So, fairly clearly, the defendant violated these requirements under both the IBC and the OSHA regulations.
For court and counsel, page 11, line 6. What other portions of the IBC codes and the OSHA regulations did you find important in this case?
OSHA 1910.37B1 and IBC 1006.1, which both deal with lighting.
Why are those significant?
Well, 1910.37B requires that lighting must be adequate and appropriate for a building exit like this one. And 1006.1 requires that any means of egress must be illuminated at all times The building is being occupied. In this case, there was a light above those stairs, but there was no switch for that light inside the chime store. So there was no way for employees to turn that light on when they went outside at night. A switch like that should have been installed long before this incident to make sure that employees could see where they were stepping.
And lastly, page 12, line 1. Next, we move to OSHA 1910.23 D1 and 1910.24H and IBC 1009.11. Why are these significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on an exposed side. Here, there was no guardrail on these stairs on the exposed side, which is obviously dangerous.
Nothing further, Your Honor.
And then opposing counsel, I don't know how you are communicating your line to me.
3029 remaining for plaintiff, by the way. Give me 1 second to reset the time. Okay. Whenever you're ready.
I'm sorry, I just got a message from opposing counsel. Is this what you want to read?
Ms. Furlani should have just sent highlighted portions through in the chat. Yes, it's going to be one question and answer on page 3.
Oh, I see it. No objection. Thank you.
And Your Honor, may Ms. Furlani also turn on her camera to read the witness's answers?
Absolutely.
And Your Honor, before we start, can we assume that you're going to instruct the jury on what exactly a deposition is?
They've already been so instructed.
Great, thank you. From page 3, line 22. Based on what you do for a living, is it fair to assume that you regularly testify in lawsuits?
Yes, no question about it. I testify and work as an expert on cases on a regular basis. To be honest, preparing expert opinions in lawsuits like this one, testifying in depositions, and testifying at trials are about 99% of what I do at this point.
That's all from us, Your Honor.
3436 remaining. Okay. Plaintiff, anything further? Or?
No, Your Honor, the plaintiff rests.
Okie dokie. All right. Do we need a comfort break, or are we ready to move on into defendant's case?
Your Honor, before we take either a break or we move on to our case, we do have a motion for judgment as a matter of law. I think I know how you're going to rule on it, but we would like to put it on the record if you'll hear it.
Yeah, let me go ahead.
Okay. We move for a judgment as a matter of law under Rule 50 of the Federal Rules of Civil Procedure. Even viewing the evidence in the light most favorable to the non-moving party, in this case, the plaintiff, no reasonable juror could find the plaintiff has met their burden of proof. And specifically, they haven't been able to meet their burden of proof on the element of an unreasonably dangerous condition. No rational juror could find that not having a guardrail or not having lights made that loading dock unreasonably dangerous. We heard about all the employees from the plaintiff specifically who went up and down those stairs for decades, a number of years. And we heard that this instance was, as far as this plaintiff knew, the first time anyone had ever gotten hurt. Based on that, no rational jury could find that the plaintiff has met their burden of proving that it was an unreasonably dangerous condition.
Okay, I'm going to deny that motion.
I'm not surprised, Your Honor.
Okay, you got 3342 left. Can we just keep on trucking? Is that all right? Is everybody good with that? Okay.
Fine
So-
with defense, Your Honor.
Okay, excellent. So defense, you may call your first witness whenever you're ready.
Yes, Your Honor. Defense calls Reese Geller.
All right, can y'all hear me?
I can hear you, Mr. Geller. May I proceed?
Yes.
Thank you, Your Honor. Good morning. Can you say your name for the jury?
Yes, my name is Reese Geller.
Where do you live?
I live here in Waco.
Are you married?
I am married.
Do you have any children?
Yes.
What do you do for work?
I am the owner of Chimes Department Store.
Where's Chimes department store located?
It's here in Waco.
How do you become the owner of a department store?
It's a family business that has been in my family since my grandparents.
Well, how long has your family owned the department store here in Waco?
Like I said, it started with my grandparents. They've had it as long as I can remember.
I want to turn your attention to this case. Are you familiar with a man named Jordan Gilmore?
Yes, I am.
How'd you know him?
Well, he used to work for us at Chimes.
Does Mr. Gilmore still work for you at Chimes?
No, he does not.
We've heard the plaintiff say that your store, it wasn't safe. How does Chimes make sure that there aren't any dangerous conditions on the property?
Well, we are, just a department store, but following general protocol, we, advise all our employees, everybody that works there, to just keep an eye out for anything that may pose a danger or threat to safety. But being a department store, we just ask our employees to keep an eye out.
Ms. Furlani, can we get what's been already admitted as Exhibit 2 up on the screen? How long have you been using this loading dock?
We've been using it since right after we moved to the location in 2005.
What do your employees use the loading dock for?
We both unload and bring products into the store from there. And then if it's a big product going out, we load it out into a customer's vehicle.
Ms. Furlani is highlighting the door. Where does that door lead to?
That door just goes into the back of the department store.
Are employees able to go in and out of that door?
Sure, yes.
How many steps do you have leading up to that loading dock?
It's just 5 steps.
I want to give you a chance to respond to some of the specific claims we've heard from the plaintiff. Plaintiff said that the cement on those steps was dangerous. Why didn't you replace those steps?
Well, we've been here for such a long time and just haven't seen a need to.
Did anyone ever tell you the concrete on those steps violated a law?
No, we've never been told that.
Anyone ever tell you the concrete violated a regulation?
No.
Plaintiff said that you should have had a handrail, a railing along those steps. When did you start using those steps?
Well, just about 2 weeks after we moved there is when we decided that it would be a perfect loading and unloading dock. So since, for the past 15 years.
And why don't you have a railing there?
Well, the railing would defeat the purpose of a loading dock. And so it would just be counterintuitive to have that.
We heard that you requested to have that railing removed from your landlord. Was that request granted?
Yes, immediately granted.
Who actually removed the railing?
That was the landlord that removed it.
Well, the landlord ever tell you that those steps, they had to have a railing?
No, he never mentioned that.
Anyone ever tell you that those steps needed to have a railing because of a law?
No.
Or because of a regulation?
No, sir.
Plaintiff told us that there wasn't enough lights above the loading dock of your store. How long had that loading dock been used with the lights that were there on January 23rd, 2019?
The 15 years that we've been there.
Anyone ever tell you that you needed to have more lights?
No.
Well, we heard from the plaintiff that he actually came to your employees and said, there's a problem with the lighting. Did you ever hear any of those complaints or concerns?
No, I never heard that.
When was the first time you became aware of the plaintiff's claim that there weren't enough lights?
The filing of this lawsuit.
I want to talk about whether or not that loading dock is safe. He told us that you moved in 2005. Is that when you started using it as a loading dock?
Yes, right after that.
Since you started using it as a loading dock, how many times did someone get hurt there?
It was just one time.
When did that one time occur?
That was, right, I think 10 years ago.
After that one employee got hurt on that loading dock, were you given a citation by OSHA?
Oh, no, nothing.
Did anyone from OSHA tell you that the way that loading dock was designed was dangerous?
No,
That you were violating any regulation?
no, sir.
I'm going to talk about how this accident for Mr. Gilmore might have happened. Ms. Furlani, can we get exhibits 3 and 6 back on the screen? The object that Ms. Furlani is highlighting in each of these photos, what is that?
That's one of the doors on the loading dock.
How does that door open?
If you're coming in from the loading dock, it opens out to you. And then if you were, going out of the store, you would push it.
I think you might have just said it, Mr. Geller, but if you're walking up those steps, would you have to push or pull that door open?
You would have to pull the door.
On January 23rd, 2019, are you aware of anything about that door that would have prevented it from being pulled open?
No, nothing.
Thank you, Mr. Geller. Pass the witness.
26:44 remaining. Let me get your time reset, plaintiff. Okay. "30 minutes and 29 seconds. Whenever you begin talking, I'll start timing."
Yes, Your Honor. Now, Mr. Geller, you're the owner of Chimes Department Store.
Yes,
As a business owner, of course, you'd agree that safety is a priority.
sure, yes.
And certainly, as a business owner, you know that there are certain rules and regulations that business owners have to follow, right?
I would imagine so, yes.
Well, I don't want you to imagine. You're the business owner, and you know that you have to follow certain rules, right?
Yes, right.
It's in fact your responsibility as the business owner to make sure your employees are safe.
Yes,
Now, over and over again on direct examination, you told us, well, no one told you there was anything wrong with your building, right?
yes,
But your safety plan at your building was just to have employees keep their eyes out, right?
yes,
Of course, you know there actually is a government agency that creates rules and regulations for you to follow, right?
yeah,
That's the Occupational Safety and Health Administration.
yes,
You know that you have to follow certain rules.
yes,
You were just here when an expert was called by deposition and talked about some of the rules that you need to follow, right?
yes, I did hear that.
You know that those rules need to be followed by you
Yes,
to keep your employees safe.
yes,
So let's talk about what safety measures you actually had in place. You'd agree that if you make employees use the stairs, they should be able to see those stairs, right?
yes,
Making sure that the stairs are visible, that's a way to keep employees safe.
yeah,
When making your employees walk on a cement platform, you'd agree that it's better to have level cement, right?
yes, like the cement that's there.
Well, you know that the cement on your platform was eroding in places, right?
A little bit.
When going downstairs, you'd agree with me. It's safer to have a handrail, right?
Generally, yeah.
Let's talk about those safety measures and what you actually implemented. Your Honor, permission to create a demonstrative?
Any objection?
We were showed this before trial, Your Honor, no objection.
Okay, yeah, go ahead.
I want to talk to you about those 3 safety measures we just talked about: the lighting, the even cement, and the handrail. Now, when you moved into the property, you knew that the light outside, that light didn't work, right?
Yes.
You knew that there was a light, you just didn't install it, right?
The light that's back there.
Right, you didn't do anything to fix it.
Yeah, we didn't do anything to it.
You also knew that in some places, some of the cement on the edges was uneven.
Yeah, a few small places.
You didn't fix this either.
No.
But when you first moved in, there was a handrail, wasn't there?
Yes.
Well, we just discussed the benefit of handrails. They prevent people from falling down the stairs.
Sure.
But you didn't want that handrail there, did you, Mr. Geller?
No, it was a loading dock.
Well, you didn't just want to remove it from the platform. You wanted that handrail completely gone, even from the stairs, right?
That was the request, yes.
And you emailed your landlord to have this removed, right?
Right.
You don't ask them to fix the lighting, did you?
No.
You didn't ask them to fix the cement that you noticed was crumbling.
No.
Instead, Mr. Geller, you only asked the landlord to remove the one safety measure you had in place, right?
Yes, the railing.
Now, you just told me a couple seconds ago that this was going to be a loading dock. That's not all it was used for, right?
No, but it is, the primary use is for loading and unloading.
Well, that may be the primary use, but you had other uses for it, right?
Sure.
But you didn't tell your landlord that actually what those stairs would also be used for is taking trash out back.
No, I didn't.
That you would have your employees walking down these stairs day after day without a railing.
Yes, for the past 15 years.
And you'd agree with me that walking downstairs without a railing, that can be dangerous.
I mean, only 5 steps.
Well, Mr. Geller, you know that one of your employees was hurt on these stairs before.
Yeah, over 10 years ago, just over 10 years ago.
That was in 2010, right?
Yes.
Your Honor, permission to publish Exhibit 14. This is one of those stipulated ones.
Yes. You don't have to ask. If you've agreed to it, go ahead and publish.
Yes, Your Honor. Thank you. Now, this is that exhibit, right? That's that documentation of this injury.
Yes.
Now, your employee said that it was dark outside during the fall, right?
Yes.
He said that the light wasn't working.
Right. Yeah.
He said that he was walking down steps on what he thought to be loose concrete.
He did say that.
He said that when he was falling, there was nothing for him to grab onto.
Yes.
And one of your managers, they filled out this form as well, right?
Yes, they did.
There was a question on the bottom of the form that asked what steps should be taken by Chimes to prevent more injuries in the future, right?
Yes, that question is answered on there.
Well, you just told us on direct examination, and I quote, that the first time you were told about this light was the filing of this lawsuit. That's not true, is it, Mr. Geller?
The first time I was told of it.
Mr. Geller, your own manager wrote in this report that Chimes should make sure that there is adequate lighting on the loading dock.
He did.
And still, you didn't install a new light.
No, I didn't.
So in 2010, there was still no lighting.
Right, no.
There still wasn't even cement.
There wasn't any repairs to cement.
And there still wasn't a handrail, was there?
No handrail, yeah, no.
Now, even though the concrete still wasn't fixed, the light still wasn't fixed, and there still wasn't a guardrail, you still made employees take that back stairwell, right?
Yes, I did.
because you didn't want people like Mr. Gilmore to be seen by your customers.
No, that's not exactly true.
Mr. Gilmore, you thought if people, Mr. Geller, you thought if people saw Mr. Geller smoking out front, that it would make you look trashy.
Oh, smoking, yes.
You didn't like that.
No, not for my business. I did not.
So you ordered your employees to do so out back.
Yes, I did.
Specifically, you had them walk down those back steps,
Yes,
take those steps out in the dark.
yes.
So let's talk about what it looked like in 2019.
Okay.
When Mr. Gilmore fell, there was still no working light, was there?
Right. Yeah.
There was still no concrete that was fixed.
There was no repairs to the. Mm-mm.
Is that a yes? Concrete still wasn't fixed?
Yes, that's correct.
And there was still no handrail.
Right.
You had control of all of those things, didn't you, Mr. Geller?
I didn't have personal control over any of those things.
Your company, Chimes, they had control to fix the light, didn't they?
Yes, we could have requested it.
You could have fixed the cement,
Sure. Yeah.
could have installed a handrail,
Yes.
but you didn't.
No, we did not.
Nothing further.
2101 remaining. All right. Any redirect of this witness?
Yes, Your Honor.
Okay,
If we can get that chart back up, I didn't catch what defense marked it as, but I want to have that up for the redirect if possible.
Sure. And Your Honor, may I mark it as Exhibit 41?
Sure.
Thank you.
All right. Whenever you start talking, you've got 2644 left.
Yes, Your Honor. Mr. Geller, you were just asked about that incident in 2010. From 2005 to 2010, how many incidents were there on those steps?
There was no incidents.
From 2010 until January 3rd, 2019, how many incidents were there on those steps?
There were no incidents.
Thank you, Mr. Geller. Pass the witness.
2622 remaining. Anything further from this witness?
Not from the defense, Your Honor.
Plaintiff? Good.
Yes, Your Honor.
All right. Awesome. Let's see. You can call your next witness, or you're going to have somebody testify by deposition.
We are going to have someone by deposition, Your Honor. Defense calls Perry Hayden by deposition. Ms. Hayden, she stipulated unavailable for hearsay purposes, and the former testimony exception applies. Rule 804(b)(1).
Your Honor, before we begin, I'm sorry, opposing counsel wanted to handle objections before the court, and I just want to know Mr. Messina's preference and Your Honor's preference. Do you want me to object as the questions come, or would you rather me do it beforehand?
Well, we've got the time stop now. I mean, defense, do you have any objection to just handling them now?
No, certainly not, Your Honor.
Okay, go ahead.
Your Honor, just one objection to one portion, and it's page 6, lines 8 through 10. Just whether or not.
Hold on. Remind me of the witness's name real quick so I can follow along.
The witness is Perry Hayden, Your Honor.
Okay, Perry Hayden, and tell me that again, Mr.
Would you like me to screen share it, Your Honor?
No, it's okay. Page what?
It's page 6. It's 114 of the entire record, if that's easier.
Page 6.
Yes, 8 through 10.
Okie dokie. I'm looking at it. Talk to me.
Your Honor, this is our only objection, and that's just under 403, whether or not a citation was issued to Chimes. We fear that this would actually mislead the jury and confuse the issues. As Your Honor knows, today is a civil case. The burden of proof for a negligence claim is very different than the burden of proof for issuing a citation. For the jury to hear that an OSHA representative did not issue a citation would confuse the issues in their mind, because they would then assume that because there was no citation issued, they must not have been negligent. We have no objection to this witness testifying to their opinion about whether or not they conform to standards, but we just object to the jury hearing that no citation was issued.
Mr. Messina?
Yes, Your Honor. First, we actually have already asked about this information before with Mr. Geller. We heard testimony. The jury's already heard it. that there was no citation issued by OSHA. So in terms of the prejudice, seems a little late on that front. As for the actual 403 analysis, there's certainly probative value here. Probative value that an expert in workplace environments and workplace safety went to this Chimes and found that there was nothing to cite. Certainly not probative value that's substantially outweighed by any danger of misleading or prejudicing the jury.
Okay, yeah, I'm going to overrule that objection. We've already heard that testimony, so there's no reason to keep it from the jury at this point.
Yes, Your Honor.
So you've got 2622. Whenever you start asking her questions, I'll start timing.
Yes, Your Honor. From page 2, lines 5 to 6. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Perry Hayden.
Same page 11 to 13. What do you do for a living?
I am a compliance safety and health officer with the Occupational Safety and Health Administration.
Page 3, 16 to 18. How long have you worked for OSHA?
Since I got out of school. So at this point, that's about 13 years.
Page 5, lines 6 to 8. All right, Ms. Hayden, how are you involved in this case?
Well, I conducted an inspection at the Chimes department store in Waco back in 2018. So I assume that's why I'm here.
Same page 16 to 22. Why did you inspect the Chimes department store in Waco back in 2010?
It was just a regularly scheduled inspection. We do that all the time. Just show up and do an inspection.
So were there any complaints that led to this inspection?
Not that I'm aware of. I went out there because it had been a while since we had been there. That's it.
Page 6, 8 to 10. Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
That's all from us on this witness, Your Honor.
2455 remaining. Do you have any cross?
Your Honor, we do have a few questions for this witness, whenever
Sure.
Your Honor is ready.
Let me reset your time real quick. Hold on. Got to make sure you have that 1 second, 21 minutes and
Of course.
All right. Whenever you start asking them questions, I'll start timing.
Yes, Your Honor. Page 11, line 16. Did you ever inspect that area behind the store at night?
No, only during the daytime.
Did you notice a light out there when you were doing your inspection?
I did. You'll see it noted in my report.
Did you ask the manager about that light?
I did, like you can see in my report.
And what did the manager say?
The manager told me that they always turn the light on when somebody goes out back at night. So that seemed good enough for me.
Did you have them turn it on for you while you were there?
No, did not seem necessary.
Nothing further.
All right. 2013 remaining. Okay. Anything further from defense?
No, Your Honor, defense rests.
Okay. Let's see. All right, we can go ahead and start with closing statements from plaintiff whenever plaintiff is ready. I mean, is everybody fine? Does anybody need a comfort break? Is anybody dying? No, I assume not.
We're okay.
We're fine
going, Your Honor.
if the jury's okay, Your Honor.
I'm looking at them right now. They look great over there. Okay, whenever you're ready.
Yes, Your Honor. Jordan Gilmore could not stop his fall, but the defendant could have. And the defendant should have. And today you heard how all it would have taken was 3 easy steps to keep Jordan Gilmore safe. A light switch, even concrete, and a handrail on the stairs. Simple safety measures that would have helped make sure that Mr. Gilmore was able to get back up those stairs safely. 3 measures the government required the defendant to take. But this defendant was more concerned with keeping their customers than they were making sure their employees were safe. The defendant quite literally forced Mr. Gilmore into a danger zone without protection. And that's why we're here today. And that's why we filed this lawsuit against Chimes Department Store. You see, today we had three things that we need to prove to you. First, that the condition of the service posed an unreasonable risk of harm. Second, that the defendant knew or reasonably should have known of the danger. And lastly, that the defendant failed to exercise ordinary care to protect Jordan Gilmore from that danger. And when we go through those three issues, it's clear. The defendant's negligent. Let's start with that first issue, that the condition of the service area posed an unreasonable risk of harm. Members of the jury, you really don't need to look further beyond this picture to see how dangerous this area was. Although it initially had a handrail, the night that Mr. Gilmore fell, and even in the 15 years leading up to then, there wasn't one. Nothing for Mr. Gilmore or any of the Chimes employees to hold on to. You heard him tell you today that even though he had to go up and down those stairs thousands of times, that he quite literally had to hold on to the handrail so that he wouldn't slip. That alone is an unreasonable risk of harm. In addition, you didn't get to meet our expert today, a professional engineer with years of experience, but you did get to hear us read his deposition. And you learned that actually required by law, they were required to have a railing. But the defendant's safety risk didn't end there. The defendant admitted to you that the cement on these steps, that itself carried a risk of harm. It was uneven. In fact, you saw these pictures of the stairway quite literally crumbling under a walker's feet. It gets worse. Because although it was technically a light outside, it might as well have never existed. Because you heard that once, 10 years leading up to the accident, that light wasn't on, and someone got hurt. Even though the defendant came and sat before you today and looked you in the eyes and told you he had no idea that the light needed to be fixed. You know that's simply not the case. Because you know that in 2010, someone was injured in the dark on crumbling concrete without a handrail. Not only that, but one of the defendant's own employees noticed what a solution would be. Turn on a light. Put a light in there so that people aren't walking down the stairs in the dark. They didn't. So that the night of the accident, Mr. Gilmore was walking in the dark. So let's look at that second issue. Did the defendant know or should have known about that danger? And members of the jury, of course they did. No one can seriously dispute that the defendant was not aware of the danger present back there. You heard how many times he had his employees out there. You heard testimonies from both sides that confirmed it. You heard the defendant
Objection, Your Honor. Point of order, there's an exhibit on the screen that hasn't been admitted into evidence. Exhibit 14 was admitted. It's a different report than the one that's on the screen right now.
Yeah, I don't think it's been admitted. I don't have a record of that.
Your Honor, I apologize. I think it was supposed to be exhibit 14.
Okay, so sustained.
No one can seriously dispute that the defendant wasn't aware of the danger of his employee, of that lot. You heard how many times today employees told him it was a problem. You heard Jordan Gilmore tell you today that he complained over and over about the light. And you heard what the manager said. I'm sorry. Said it wasn't high on the priority list. But wait, the defendant says, well, an OSHA representative came to the store and they never cited us. We had no reason to believe that the stairs out back were actually a danger. Members of the jury, that's absurd. Yes, they weren't issued a citation, but remember why they weren't. You heard us read that deposition today. They asked the manager about the lighting outside. And remember what the defendant's manager said, that the light automatically came on at night. And the OSHA representative believed him. But you heard from the defendant that that wasn't true, that not once in the 15 years did that light work. That's why the citation wasn't issued. Not because the defendant didn't do anything wrong, because the defendant hid the truth. And that brings us to the third element. Whether or not the defendant failed to exercise ordinary care to protect Mr. Gilmore from this danger. Now, members of the jury, as you'll learn in a moment when the judge instructs you on the law, it's pretty easy to understand what ordinary care is. Basically, what you're going to look at is whether the degree of care that was used by Chimes was the amount of care that any other company in the same, similar circumstances would have used. And I want to take you through this element step by step to show you just how badly the defendant failed here. The defendant told you here today that safety is important. That as an employer, they admitted they owe their employees a safe place to work. And you heard that it's not even just a choice of the employer whether or not to make a property safe or not. The law requires it. Our community demands it. Mr. Gilmore deserved at least that much. But you see, when the defendant's business first moved in, well, they had at least one safety measure in place, the handrail. That wasn't important to the defendant. It got in the way of making sure that they could get their merchandise quickly and cheaply out of the store. So what did the defendant do? Well, they didn't just remove a portion of the rail so that there could be a loading dock. They didn't remove the whole railing and then forbid anyone else from using these stairs or building a ramp. Instead, they just pulled it off and continued to order employees down those stairs, literally gripping onto the wall in the dark. Today, the defendant wants you to excuse their behavior. They try to say that they weren't required to have a handrail there because it was a loading dock. But that's not what that back set of stairs was meant for. The defendant himself had to admit that on my cross-examination. But even though that's what he told his landlord, what he didn't tell his landlord, that he was installing a dumpster back there, that he was having employees essentially use this dangerous stairwell as a break room. Members of the jury, just because you get to require your employees to take trash out there doesn't mean you get to treat them like trash. These are people, not to the defendant. You heard him admit to you on the stand today that having Mr. Gilmore take a break in a safe area would make him look trashy. These are people who relied on their employer to have a safe place to work, not risk their lives by taking out the defendant's trash. Not only did the defendant banish their employees to this space, they even went so far as to require their employees to clean up back there. They wanted to make sure that their employees kept that area clean and presentable. And this tells us everything we need to know about this case, everything that the defendant was worried about. Because the defendant was more worried about keeping customers than they were worried about the safety of their employees. More worried about being presentable, getting money, doing business, and keeping Mr. Gilmore safe. Then they had the audacity to come before you today and point the finger at Mr. Gilmore. They came up to you in opening statement, and the first words out of their mouth was, it wasn't their fault. They told you that Mr. Gilmore was rushing up those steps. You heard from Mr. Gilmore today. He was walking up those steps. He told you he was being careful. He told you he was holding onto the wall and using the little bit of light coming out of the door to guide his path. That's why when you're asked if the negligence of the plaintiff, Jordan Gilmore, contributed to his injury, you can answer no. When you're asked if the negligence of Chime's department store caused this injury, you can answer yes. When on the very next page, you're going to be asked to assign percentages of responsibility. We're going to ask you to assign Chime's department store 100% responsibility. We waited for an explanation of why you would knowingly let your employees go down an area that you admitted wasn't safe. And we never got one. All it would have taken to prevent this injury is a light switch, a handrail, and some even cement. Mr. Gilmore deserved that. Find them liable.
Okay, so 8:02 left. When y'all go sub 5 minutes, would y'all like hand signals?
I don't think I'm going to get there, Your Honor. I think I'm okay.
Okay. Ms. Doig, do you want me to do that? I can do 5, 4, 3, 2, 1.
No worries. I hope I won't take more than 5 minutes on rebuttal, Your Honor.
Okay, so 8:02 left. Just thought I'd offer.
If I go that long, you can unmute and tell me to be quiet.
Okay, we'll do. Okay, so you've got 24:55 left. And sorry, let me reset your timer. Okay, whenever you start talking, Mr. Nacino, I'll start timing.
Yes, Your Honor. In addition to any admitted exhibits, are we okay to put up some portions of the jury instructions during our closing argument?
I mean, plaintiff did it. Yeah, that's fine.
Thank you. $10,000. The plaintiff went up and down those steps 10,000 times in the daytime, in darkness, when it was well lit, when there weren't any lights at all, 10,000 times. And before this time, not once. Not once did he slip, stumble, or fall. Not once did he get hurt. The reason this time was different is because this time the plaintiff, he wasn't thinking about being safe or about being careful. He was thinking about that cold wind blowing across that back lot. So he rushed to get back inside without opening that door the whole way. Members of the jury, people make mistakes. We're not saying the plaintiff is a bad person. The fact is that this fall, it wasn't Chime's fault. Now, we took on a burden today, an affirmative defense, to prove that it was the plaintiff, his carelessness, that caused his fall. But as the judge will explain, if the plaintiff, if they can't meet their burden first, that's it. If the plaintiff can't meet their burden, nothing else to talk about. Today, as we sat and we listened to the evidence and the testimony, it became clear. Plaintiff, they're not able to meet their burden. Start with the first of those two reasons we told you that you were going to find for the defense today. this fall, it wasn't Chime's fault. The judge will explain, the plaintiff had to prove that there was a condition on Chimes's property that created a substantial risk of harm. Today, the plaintiff, they pointed to the loading dock. They said this is that unreasonable condition, that dangerous condition. Remember to the jury, this was a 2-foot loading dock, not more than a couple feet off the ground. The plaintiff says that this was unreasonably dangerous. This was the unreasonable condition. I'm not a particularly tall person, but this loading dock, it would barely come up to my waist. And we're not saying that it's not possible for someone to get hurt on this loading dock. It's not possible for someone to fall off it. What we are saying, it's not possible for this 2 feet off the ground to be an unreasonable danger. A person with the worst fear of heights in the world would look at this and they think, okay, that's fine. Plaintiff, they kept showing you Exhibit 14. They said, this report, this is our smoking gun. This proves that back steps were unreasonably dangerous. This is one report from 2010 where one person slipped on those steps. Today, the plaintiff said he had gone up and down those steps 10,000 times in just 10 years. And those steps, they've been there for 15 years. So aside from the plaintiff, think about all the other employees who are going up and down those steps. Not just for 10 years, but for 15. Tens of thousands, maybe even hundreds of thousands of trips up and down the steps. And the best the plaintiff can do, the best they had was one time. One time where the person said they weren't even hurt that badly. This isn't evidence of a dangerous condition. It isn't evidence of anything. The plaintiff's second element was they had to prove that Chimes failed to act with ordinary care. Failed to act like a reasonable store in the same or similar circumstances. And for this, they pointed to regulations. They said, well, those steps, they violated some regulations and industry standards. We heard about the loose concrete. We heard about the railing. Now there wasn't one. But we also heard testimony from one person today who has no dog in this fight. And that's Perry Hayden, the inspector from OSHA, who you heard deposition testimony from. The plaintiffs, they talked about the lights, and we'll get to that in a second. But on the railing and the concrete, those are things Mr. Hayden could see. When he saw the railing and the concrete, he didn't write a citation. He didn't tell Chimes, these are dangerous. You should think about changing them. He didn't say there was a safety issue at all. Today, the only person who told you that the railing and the way the concrete was violated some kind of standard or regulation was that professional expert hired and paid for by the plaintiff. And when the railing and the concrete, when they didn't work, the plaintiff, they turned to the lights. They said, well, there wasn't enough light at the loading dock. No one could see the steps below them. We heard the employees, they used the light from the inside of the store. That's why they kept that door open. And light from the store aside, we heard that the loading dock was like that for 14 or almost 15 years. We asked the plaintiff, all those times you went out there, do you remember the light ever being on? He said no. But now the plaintiff, they want to say, well, this condition that was the same for 14 years, where no one had ever gotten hurt, one person slipped once, that was dangerous. Members of the jury, again, the only person who told you that was the professional witness, hired and paid for by the plaintiff. This is the verdict form. Because the plaintiff has failed to meet their burden of proof on question 1 next to chimes, you can write no. But there's a second separate reason to find for the defense. This fall, it was the plaintiff's fault. As the judge will tell you, we had to prove in order to meet our burden that the plaintiff failed to act like an ordinary person, exercise ordinary care that another person would in the same or similar circumstances. So what were the plaintiff's circumstances? Well, we saw what those steps and that door looked like. Door slightly ajar in a way that blocked the path back up those steps. Left just a narrow bit of concrete on this top step for someone to put their foot on. And what does a normal, reasonable person do in these circumstances? They open the door. They pull it open so that they can step onto that top landing, no problems. Today, we heard that the plaintiff wasn't thinking about, can I step on the right place on the top of that landing? They were thinking about getting back inside because it was cold and it was windy. Members of the jury, we don't have to speculate about what a reasonable person would do faced with that circumstance. We actually heard about what a different person did. The plaintiff told us that his coworker, when she went to help him get back inside the store, when they went up the steps, she pulled the door open. And she got back up there, no problems. Didn't slip, didn't stumble, nothing. Didn't slip, didn't stumble while she was dragging the plaintiff up the stairs with her. The plaintiff says, well, I couldn't have opened the door. The evidence showed, yeah, he could have. And it would be one thing if the plaintiff had a good reason for not opening the door. If it was stuck, if there was some other problem, there was something in the hinges, but we didn't hear about that. Instead, when we asked the plaintiff, well, why didn't you pull open the door? Why didn't you ask your coworker to open the door wider? He said, well, it was cold. We were worried about the wind. We heard that in those same conditions, the cold and the wind, the plaintiff's coworker, she opened the door. And she walked up without any problems. The evidence has shown this fall, it wasn't Chime's fault. It was the plaintiff's fault. And so on question 1, next to the plaintiff, Mr. Gilmore, you can write yes. Members of the jury, when someone gets hurt, it's easy to blame a faceless company that just happens to be nearby. It's easy to point blame when it's just a company. But today, you met the face behind Chime's department store. You heard about everything the Gellers have done here in Waco, how they've built a small little local institution. In their closing argument, plaintiff talked about, well, defense, they treated their employees like trash. That's not what we heard today. We heard about a company where over 15 years, there was one workplace incident. That's not treating employees like trash. That's bringing your employees into the Geller family. when you make your verdict for the defense, it doesn't mean that you're endorsing everything they did and that you're saying they were 100% perfect. But what it does mean is that for this fall, for this night, in January 2019, it wasn't Chime's fault. It was the plaintiff's. That's why we're asking you for a verdict for the defense. Thank you.
Any rebuttal?
Briefly, Your Honor.
Okay, let me put your time back on. As instructed, I won't do the Vanna White hands for you. Okay, whenever you start talking, I'll start timing.
The defense wants you to blame Mr. Gilmore because he smokes and because on January 23rd, he was cold. They want you to disregard their own witness who had to admit today that he knew there were issues with the back area. They want you to ignore our expert, the only expert today who wasn't given incorrect evidence, incorrect information from the defendant themselves about the light. But like the defendant told you in their opening statement, they could have done more. Like Mr. Geller told you on the stand today, they had the ability to do more. And like the Chimes manager told Mr. Gilmore after he fell off their stairs, they should have done more. Members of the jury, it's not enough to say, well, this hasn't happened before. This was a disaster waiting to happen. Members of the jury, opposing counsel just told you that the Geller family treated their employees like family. Making your employees walk downstairs in the dark, literally gripping onto the wall, tripping over loose concrete that they complained about over and over again, that's not family. That's not normal. No reasonable company ignores dangers they knew about. When you create a dangerous situation, you can't blame the people you put in it. It wasn't Mr. Gilmore's fault. It was theirs. Find them liable.
Okay, you have 5:48 left. Okay, so we're going to take a momentary break so that the judges can submit their ballots, and then when we're done with that, we'll have a brief bit of commentary. So y'all, if you need to skirt to the bathroom or whatever, feel free to do that. Just, leave your cameras on.
Great job, Ryan. Sorry, I caught you when you're drinking water.
Yeah, you did. Really good round, Mark. Really,
Yeah, that was fun.
That's good.
Nice job, guys.
Thank you. Thank you for judging.
Yeah, these are always fun. They're not always that close or that good. So, good job.
Agreed. That was a fun round. Thank y'all. Appreciate it.
Thank you.
All right. We can't hear Judge McIntyre probably, can we? Let's see.
Can you hear me?
Yes.
Oh, heck yeah. Okay. You guys did so great. Like, so wonderful.
Did everybody submit their ballots?
Yes.
Judges? Yeah, okay.
Yes.
So then if we want to do comments, only instructions are to keep it brief. So let's do Judge Walraven first.
Okay, I'll try to keep this as brief as possible. So with that, you both are great. I think we're only going to say some things that are hopefully going to add value. My name is Mark Walraven. I'm an oil and gas litigator in Oklahoma City, and fortunate enough to be on the winning national trial competition team in 2012. So we've done a few of these. Look at my comments here. First and foremost, I would say defense for you, your opening line or your opening theme was it wasn't their fault. I would have gone, you had a better line, a paragraph or two down that was the faster thing wasn't the safer thing. I think that's stronger. I wouldn't open up with it wasn't their fault. Just me on that one. Also, when you're doing your directed verdict motion, we all know what the outcome is going to be in the process, but don't say it. If you're gonna make the motion like you're gonna win it. Don't tell the court that he's gonna rule against you. Your best fact to me was that the plaintiff didn't open the door all the way. I think that your best exhibit that I saw was Exhibit 3 next to Exhibit 6. I love that one. You put a lot of emphasis on it. I just wanted to let you know that because that's what struck home with me. For the plaintiffs, I redirect. I mean, I understand you felt like you probably, had a pretty good situation, but I liked his cross of your plaintiff. Don't leave it open to chance like that. Especially in a competition like this. I understand there is the rare power of walking away saying, I don't even need to redirect this witness. But where you only have one live witness, that's probably not going to be the case here. Maybe if you had 2 live witnesses, you could get away with that on one of them. So again, that's just my thought. I thought, a little bit stronger ending than find them liable, something closer along the lines, based on everything that we've showed you, respectfully ask that you find the defendant liable. A little bit more to it right there. The best fact I thought for you, which I thought could have been highlighted a little bit more, was the defendant's affirmative action of taking away the railing that I thought would have resolved all of this. Like, in light of the 2010 incident, choosing to take away a safety feature, I thought was huge and could have been emphasized. So thank you both. Awesome job. This was actually, in my opinion, a very close round. And I don't usually see that, especially this early in the competition. And thank you guys for competing, by the way. It's awesome to see people come to Top Gun to do this. So,
All right, let's go with Judge Cunningham next.
Hi, can everybody hear me okay?
Yes, ma'am.
Okay, sorry, I've got a really low connection, so I'll try to be quick. I'm Misty Cunningham. I'm a board certified trial attorney and in personal injury in the state of Texas. So I've in this case hundreds of times. And so this is definitely up my alley, and I think you guys did a great job. I'm going to share 2 quick positive points and then something that you guys on both sides can use. Defense, great positioning on your camera and smooth transitions. Keep that up. You did great. Plaintiff's work, I love the chart. Visualization is great, especially over a Zoom trial. So please keep that up on either side. On the plaintiff's case, generally for both of you, I've defended, represented multiple big companies like this before, and you can make a lot of hay, exactly with what Ms. Mark just said, on just kind of slowly attacking the business aspect. They took away a railing, but it's a very low cost to invest in the safety of your employees to put up a handrail. It's probably less than $300 or $400. And I don't know if you can use damage amounts, and you're probably not encouraged to, but it's an easy way to invest in the safety of your employees. So this big company, he's sitting there in a leather chair, he's making all this money, even as a family, his family's got money from this company, yet it's an easy thing to fix. The comments about calling the employees trash, and they have the audacity to do these things. I personally, I'm all about dramatics. I love trial law, but that is pretty harsh with a pretty easygoing company that's family owned. You could probably make more hay in saying, it's not very difficult for them to invest in their employees this way. I mean, just really hammer home on the fact that this is a big company and it's easy fixes for them. And he simply got hurt. So I think those are all easy ways. It's understandable how they got injured. And defense, I loved how you ended there by just kind of summing it up and making it just succinct there on why they weren't in fault, and owning that there was something that occurred, but that they weren't negligent on this day. I think that's good. And I also echo Mark's comments on plaintiff's closing, just saying don't hold them liable. There's that you can kind of powerfully end. You are the last person to speak as a plaintiff. So just say, plaintiff and I, whatever the name is during the competition, we're waiting for your verdict to come back to make him whole. So please go back, hold the defendant responsible as unreasonable in this case. We're waiting for your verdict. Just something very powerful to end the entire thing. So great job. I also echo Mark again, and that this is a very close competition, and I don't usually see that in this early in the round.
All right, let's do Judge Peterson.
Hello, everyone. Andrew Peterson. I am a defense lawyer, have been for the last 10 years. This was a really fun round. It was very close. It came down to closing, and you both did a great job in close. So, plaintiff, Ms. Doig. So, I think you have a good ability to bring drama into the case, but I think you're emphasizing the wrong areas where you're bringing your drama. The drama is not necessarily how the accident happened or how your client got injured, because it doesn't sound like his injuries are very bad. Some injury, but not terrible. Your drama is in the fact that the store lied to the OSHA inspector. They lied. Don't be afraid of that word. They lied to the OSHA inspector. And maybe someone told you not to say that. Don't be afraid of that word. That's a good word when you have the evidence to hold them to it. Call them liars. They lied. They don't care. The owner doesn't care. He knew about the report. He said he didn't, but he knew at least about the report, but he didn't know about anything else that all the employees have been telling his managers. Why? Because he doesn't care. Finally, they don't take responsibility. They're here fighting over this. They've known about it for over a decade, and they're not doing anything about it. Your drama is in their actions and how they acted in the case, not in how exactly the accident occurred. That's where the jury's going to get mad. That's where you get your money. The thing that I would like to see from you is I would like your opening to match your closing. And I felt like though there was a difference in some of the information that was presented in the arguments that were made. So look over your closing that you wrote down, make sure it pairs up perfectly with your opening. And of course, I agree with all the other comments. Those were all very good as well. The railing was something I was waiting to hear about. And the fact that they actively took it out of there, I mean, I know some plaintiffs' attorneys would make a gross negligence argument out of that. On the defense side, excellent cross-examination, really liked it. The impeachment, you didn't need to do it. You'd made your point very well there. I'd say engage more directly in your opening statement. Whatever plaintiff throws out there, try to find some things that you can at least talk about and either blow up or directly engage and show, they said this, here's why that's wrong. or doesn't make sense. The OSHA inspector thing, I would probably move my case away from that, because that goes into the lie that your client told the OSHA inspector. So I try to stay away from that. The 10,000 steps thing is powerful. That is a winner. Unreasonably dangerous is a winner. That use of humor to deflate the plaintiff's case and the drama that she was creating with her argument was fantastic. The person most afraid of heights in the world would say, not that bad. I thought that was an excellent way to deflate the situation and lower the temperature of the room. So if I were defense, I would focus on not unreasonably dangerous. We've got probably 10,000 just by him, hundreds of thousands of steps over the course of every employee in the joint. No one's been hurt except for one person. And they even said it wasn't that bad. So when we're talking about a scale of it, so the way I do this cross-examination is I get people to talk about safety ratings. So if we're talking about a safety rating here, their safety rating is 99.99999999999%, right? Pretty good. Unreasonably dangerous? Probably not. And then compare that with the acrobatics of the plaintiff, right? He has walked the same way down those stairs every single time. What was the difference? Difference was he chose to be acrobatic this time and try to monkey around the door. It was straight out. There's no handle on the side. There's no grip on the other side. It's just a straight bar that you can't grab onto. And he tries to scoot around a 4-inch gap. No adult would do that. That's the activities of a teenager or someone goofing around. And if someone's goofing around, it's their fault if they get hurt. That's why the doctor always said, no more jumping on the bed. So thank you very much for the round, guys. Appreciate it.
All right, Judge McIntyre, if we can just keep them brief.
No problem. This will be really quick. First off, you guys both did such an incredible job. I was so happy to be able to judge this round and see both. Starting off with plaintiff, I really wanted to hear more about the hand railing being taken away and lying to OSHA. And I know that's been addressed by the other judges. But I think especially the lying to OSHA, I mean, that was huge. When that came out, I was like, what the heck? So I kind of wanted to hear a little bit more of that. And then I know that this has already been addressed as well, but I didn't love the find them liable at the end of your closing. I know that's a personal preference. I agreed with Judge Cunningham with maybe using the word responsible. I just feel like it's more of a layman's term word and it kind of flows better. You also did a really good job with addressing the arguments that defense brought up. Every single time you got up, I could almost rely on you to go back and be like, well, in defense's opening, they said this, or in defense's direct, they said this. And you got to the arguments every single time and addressed those before you even got to your points, which I thought was great. Defense, I love the 10,000 steps. I thought that that was great. I wanted you to address the OSHA lying incident a little bit more. I felt like that was kind of just left open and hanging there. And then the last comment I had was the first sentence in your opening, which was where you said, this fall wasn't their fault. I just feel like you should have came out with a little bit more of a punch. That's all. But you guys both did a great job. Good job staying poised and like in control. They did wonderful.
And Judge McIntyre, who are you and what do you do?
Oh yeah, sorry. I just graduated from Baylor in 2020. I am an associate at Dyke & Gossett in their Austin office. I work primarily with commercial litigation and I do a little bit on the plaintiff side and a little bit on defense.
Okay, so I'll be even more brief than that. I think you've heard, how to sort of sculpt the case a little bit better. Ms. Doig, I'm saying that wrong again, aren't I? Doig, yeah, there it is. Maybe that's the first time I've said it correctly. You do pauses for dramatic effect, and there were times where I thought that kind of derailed what you were doing, probably just because you're doing it too frequently, and sometimes it's like, it's like a crescendo, right? With a drum, you want it to be on something that you want to hang in the room. And I would say if you're doing it probably 3 or 4 times in the course of, your opening or whatever it may be, maybe cut it down a little bit, just because then it's kind of like, okay, are you done, or are we still going? That was, my one small comment there. The only thing I'll say for Mr. Nacino, yeah, the impeachment thing I think was a waste of time. It burns up your time, and so I would just, definitely be sure that if you're going to try to stick, somebody with being untruthful, that you're, very, very sure of what you asked. I mean, not necessarily a last resort, but I would certainly be sure of it just because it eats up, that precious little bit of time that you have. And I'm Kyle Gardner. I'm a law clerk for the federal magistrate here in Waco. So good job, guys. Good luck in the next rounds.
Thank you all so much.
And judges, y'all are free to go. They got your ballots. So
Excellent. Thank you.
Guys, good
Thank you
luck.
guys again. Good luck.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon.
I believe we're still waiting from Defense Counsel Summer Combs. She just came on. And we have our witness, David and Jessica, correct?
David's here. I'm not quite sure where Jessica is right now.
She has 3 minutes before I tell PC Professor Wren, which she does not want me to.
Either that or we'll have to call the sheriff, Your Honor.
That's true.
We'll have a much worse weekend, that's for sure.
She just entered.
I'm so sorry.
Are we here? Jessica?
Yeah. Is our camera on?
Oh, sorry.
We're great. Okay. Very good. Well, he didn't. Let me get one more thing. One moment, please. All right, folks. Going to call for pretrial housekeeping matters, the matter of Jordan Gilmore versus Chimes Department Stores, Inc. Is the plaintiff ready to proceed?
We are, Your Honor.
Is the defense ready to proceed?
Yes, Your Honor, we are.
Is there any housekeeping matters?
We do, Your Honor. Maybe make appearances first?
Sure.
Good afternoon. My name is Ryan Nacino, appearing on behalf of the plaintiff, Jordan Gilmore. Today, I'm joined by counsel.
Good afternoon, Your Honor. Nicole Furlani for the plaintiff.
All right.
Once the defense has made their appearances, we have a couple of housekeeping matters and some stipulations to put onto the record.
All right. Defense.
Yeah, yes, Your Honor. Good afternoon. My name is Matthew Hobbs, and I, along with my co-counsel, Summer Combs, we will be here representing the defendant in today's case. That would be Chimes Department Store.
All right, sir. All right, let's proceed to housekeeping matters. Plaintiff.
Yes, Your Honor. It's our understanding that you have an electronic copy of the case materials. We just want to confirm that before we start getting into the weeds on
Correct.
anything. Now, all exhibits in this case have been pre-marked as joint exhibits. For the convenience of the court and counsel, we ask that those exhibits retain those markings regardless of the order in which they're admitted.
We'll see how that plays out.
Yes, Your Honor. Once an exhibit has been admitted, do we have your permission to display it on the screen, or would you like us to ask each time?
You may display any exhibit that has been admitted.
Understood, Your Honor. We ask for constructive sidebars. That is, we ask that all objection arguments be heard constructively outside of the jury's presence.
Correct.
And our last housekeeping request, Your Honor, it concerns opening statement. Now, normally, the party with the burden of proof, in this case, us, wouldn't comment on defense's theory in opening statement. However, in this case, the defense has raised an affirmative defense against our plaintiff, alleging that our plaintiff's negligence is what caused his injuries. They carry the burden of proof on that affirmative defense. We ask permission to be able to address that affirmative defense in our opening statement, because otherwise we wouldn't be able to comment on it to the jury until closing argument.
We're going to use the rules of federal procedure and evidence in regards to opening statement, closing argument, and all matters in between.
Understood, Your Honor. No more housekeeping matters from the plaintiff. Once the defense addresses anything, we have a couple stipulations that are substantive for the record.
Thank you, sir. Proceed, defense.
Yes, Your Honor. I believe I'm sorry, is it Mr. Nassino? I just want to make sure I'm pronouncing your name right.
It's Nassino.
Nassino. I believe Mr. Nassino has covered all the housekeeping matters we had. I believe in the conversation we had pre-trial, there's a couple of stipulations that we've actually agreed to just to make the court's job easier today.
We're all for that.
Yes, sir.
Proceed with substantive matters, plaintiff.
Yes, Your Honor. First, the parties have agreed to pre-admit a couple of exhibits in this case. Those exhibits are numbers 2, 3, and then 15 through 21.
And that's our understanding, Your Honor. We have no objections at this time. That was an agreement we had beforehand.
Those items are admitted for all purposes.
Your Honor, does that include displaying them during opening statements?
Correct.
Thank you. Second substantive matter to put on the record, Your Honor, is the parties have agreed that there won't be any evidence or testimony about the plaintiff, Jordan Gilmore's smoking habits. We're going to talk about how he was on a smoke break the night he got hurt, but in terms of his habits, the number of packs of cigarettes he had a day, a week, if the parties have agreed, we're not going to put that evidence on the record.
I will enforce that.
That's all that was for the plaintiff, Your Honor. I think defense has 1 or 2 issues to put on the record as well.
All right, proceed, defense.
Yes, Your Honor. In agreement with opposing counsel prior to trial, we've agreed to exclude any mention of Jordan Gilmore being fired. And Mr. Nassino, I just want to make sure we had a little bit of confusion before trial. Are we still in agreement on that?
Oh, we'll say that he's not employed and he was last employed by the defendant. Is that right?
Perfect. That sounds good to me. And then, Your Honor, the only other thing we had is we've agreed to exclude exhibits 38 and 39 today, those being 2 emails in between OSHA representatives.
Is that agreed?
That is, Your Honor.
Okay.
And with that, Your Honor, the defense is ready to proceed. I'm sorry, Your Honor, go ahead. I'm sorry.
Fine. 38 and 39 will not be used for any purpose in the trial of this matter. Anything else?
No, Your Honor, that concludes the defense's substantive matters.
All right. We will now take announcements for actual trial in the matter of Jordan Gilmore versus Chimes Department Stores, Inc. What says the plaintiff?
Yes, Your Honor, we're ready for opening statement.
Defense?
Yes, Your Honor, we're also ready for opening statement.
Proceed with opening statement, plaintiff.
Yes, Your Honor. May it please the court.
Proceed.
Their dock, their steps, their fall. It's a Wednesday night in January. Jordan Gilmore is standing at the bottom of a loading dock behind Chimes Department Store. He takes a look at his watch. 7:05. Breaks over. He takes the last drag of a cigarette, throws it away, and turns to go back inside the store. And he goes slowly. He puts his left hand on the wall next to the steps. Because when he looks down, he can barely see the steps in front of him. It's pitch black. And as he walks up the steps, he goes to put his right foot on the landing. And what he can see is his coworker holding the door open for him. But what he can't see is the hole in the concrete on that landing. The place on that landing where the concrete is loose, where that step is broken. Jordan Gilmore, he puts his foot down. He slips. He loses his balance. He falls off of that landing dock. Members of the jury, you're going to learn that that loading dock, it was operated, controlled, maintained by the defendant, Chimes Department Stores. Today, you're going to see what those steps looked like, how they were jagged, weathered, worn down, holes on the top step and on the bottom step, broken concrete on every step. Today, you're going to learn that it was those steps, the dangerous condition they were kept in, that caused Mr. Gilmore to fall off of that loading dock. It caused him to get hurt. Mr. Gilmore, can you turn your camera on for us? This is Jordan Gilmore. That night when he fell was in January 2019, over 2 years ago. Today, Mr. Gilmore, he can't work. He can't walk. He can't do any of the things he used to do. Thank you, Jordan. You can turn your camera off. And today, we've filed a claim against the defendant for Mr. Gilmore and his injuries. And as the plaintiff, we have the burden of proof. We have to prove that it was the defendant's conduct, their negligence, their failure to act like a reasonable store that caused Mr. Gilmore to get hurt. And to meet that burden, we're going to prove 3 facts. 1, there was a dangerous condition. 2, they didn't fix it. And 3, because of that dangerous condition, Jordan Gilmore got hurt. Let's take them one at a time. Fact 1, there was a dangerous condition. Today, you're going to see the defendant's loading dock. And you're going to see what the steps on that loading dock look like. Weathered, worn, and jagged. Holes in the steps from the railing that they ripped out years ago. But you're not just going to see that this is what the steps looked like in 2019. You're going to hear this is what they looked like for years. Today, you're going to hear about a report from an employee for the defendant back in 2010, where he slipped on those stairs, where he told the defendant that he fell and got hurt because of loose concrete on those steps. That brings us to the second fact that we're going to prove. They didn't fix the danger. Today, you're going to hear deposition testimony from an expert professional engineer. And they're going to tell you the obvious thing, that those steps, they were dangerous and they needed to be fixed. Today, it's going to be undisputed, that from the time the defendant moved into that store until Mr. Gilmore's injury, they made no repairs to that concrete. Didn't fill any of the holes, didn't replace any of the steps, didn't fix any of the missing chunks. Brings us to that last fact we're going to prove. The dangerous condition caused Mr. Gilmore's injuries. Mr. Gilmore, he's going to be our first witness. He's going to tell you about those steps, how he walked up them on the night of January 23rd, 2019. How he was being careful and how when he put his foot down on the landing, he lost his balance. He slipped. The same landing where there's a hole in the step. Same landing where the concrete is worn away. When Mr. Gilmore is done testifying, it'll be clear. The defendant is responsible because it was their dock, their steps, and their fault. Now today, the defense, they're going to try to say it wasn't us. And say we didn't do anything wrong. They might even try to point the finger somewhere else. But as you hear the testimony and listen to the evidence, remember who that loading dock belonged to. Remember who was responsible for those steps. And when you listen for those two things, it'll be clear who's at fault for Jordan Gilmore's injuries. So at the end of this trial, we'll ask you to return a verdict for the plaintiff. Because it was their dock, their steps, and their fault. Thank you.
Defense wish to make an opening statement?
Yes, Your Honor. May it please the court. Your Honor, opposing counsel, members of the jury. Accidents happen. When you've made a mistake, it doesn't mean that someone else is to blame. On the night of January 23rd, 2019, Jordan Gilmore, the plaintiff in today's case, was walking up the steps on the back loading dock outside of Chime's department store. Just like he had done hundreds of times before. He had just finished his shift. It was coming around the end. He needed a break before he got off from work. So he grabbed a buddy, went out back, and had himself a cigarette. But when he got out there in that cold January night, he thought to himself, I can't stay out here very long. It's too cold. So he took one more pull on his cigarette, threw it on the ground, and proceeded back up the steps, those same steps he had gone up hundreds of times before. But this time, something was different. This time, as he walked up the steps, Jordan's friend, the plaintiff's friend, was holding the door open just like this. So Jordan approached the door, leaning against the wall like he always did. But as the plaintiff got to that door, instead of asking his friend to open it up the rest of the way, the plaintiff walked around the end of the door and near the edge of that platform, doing something different than any other time he had walked up those stairs. And as his foot got to the top of that platform, and he put his right foot down, he could feel himself slipping. As he went around the edge of that door, in the 1 foot gap that was left, he felt himself falling. He tried to stop himself, but by that time, it was already too late. And that's when the plaintiff fell 3 feet off of the loading dock platform and hurt his knee. Members of the jury, those choices to rush up the stairs because it was too cold outside, to skirt around the end of the door, near the edge of that platform, those were mistakes. And just because you make a mistake and an accident happen, it doesn't mean that someone else is to blame. Now, today's case is about negligence. The plaintiff holds the burden of proof today. They must prove to you by preponderance of the evidence, that is, that it's more likely than not that the actions of Chimes department store were the cause of the plaintiff's injuries. The members of the jury, I expect you're going to hear a lot about the what today. In fact, you just heard from opposing counsel that they intend to tell you the what and the who. But what they won't tell you, what we as the defense will tell you today, is the why. And we heard a few moments ago that the plaintiff is going to call some witnesses up before you today. In fact, you heard that the first witness that they're going to bring before you is the plaintiff himself. I want you to listen very closely whenever the plaintiff is on the stand to what he has to tell you. You're going to hear that he's walked up those stairs 20 times a week for 10 years. You're going to hear that time, on that cold January night, he did something different. We also anticipate you're going to hear from another one of the defense witnesses by deposition, and that's Kelly Daines, an expert witness that the plaintiff is bringing before you today to testify about what the laws are here in our state. But what Kelly Daines is also going to have to tell you is that at the time that this accident happened, not even 7 months before, an OSHA inspector came out to Chimes department store. And as opposing counsel said, that platform and that railing hadn't changed in over a decade. And not 7 months before the plaintiff was injured, an OSHA representative came out and approved everything that was going on with that loading deck. Because what Ms. Daines is going to have to tell you is that loading decks, they're not required to have railings. After the plaintiff is done calling their witnesses today, it will be our turn as the defense. And as a defense, we brought an affirmative defense today, which means we also have a burden. We have to prove to you by preponderance of the evidence, that is, that it's more likely than not, that it was the plaintiff's own actions, the plaintiff's mistakes, as unfortunate as those mistakes are. And no one today is going to contest that what happened to the plaintiff isn't unfortunate. But that those mistakes, those actions taken by the plaintiff were the why as to how he was injured on that cold January day. In order to do that, we're going to call the owner of Chimes department store. You're going to get to hear from Reese Geller herself. And when Ms. Geller's up here before you, she's going to tell you exactly what we've already talked about. She's going to tell you about the actions that her company took. She's going to tell you about how just a couple months before, the OSHA inspector came out and said everything's fine with that platform. And then you're going to get here the deposition testimony from that expert himself. And he's going to tell you that everything checked out with that platform, because loading docks, they don't need railings. And at the end of today's case, when Judge O'Neill comes before you and charges you as the members of the jury, you're going to know what answer you have to put down. You're going to know that Chimes department store, they're not liable. They're not liable for an accident and a mistake that happened. Because when you make a mistake, it doesn't mean that someone else is to blame. Thank you.
Call your first witness.
Yes, Your Honor. Plaintiff calls Jordan Gilmore.
Mr. Gilmore, having been previously sworn, you may proceed.
Thank you, Your Honor. Mr. Gilmore, good afternoon. Can you say your name for the jury?
Jordan Gilmore,
Where do you live?
right here in Waco, Texas.
What do you do for work?
Currently, I'm unemployed, but I used to work at Chimes Department Store.
Well, what's the last day that you worked at the defendant Chimes Department Store?
January 23rd, 2019.
Why is January 23rd, 2019 the last day you worked there?
That was the day my leg got injured while I was working and haven't been able to return since.
Mr. Gilmore, how'd your leg get injured?
I was taking a smoke break and I was walking up the steps to get back in. My foot slipped, and instead of falling back on my back, I tried to jump down and land on my feet. But landing on my feet, all my weight went to my right leg, lost balance, and ended up on my rear.
We're going to talk exactly about what happened to you in a minute, Mr. Gilmore. Without going into too much detail, can you summarize your injuries?
I messed up my knee. I ended up needing a knee. I needed to go under knee replacement surgery.
Well, let's start back at the very beginning. What was your job for the defendant?
I was a cashier. I worked the front of the store, ringing up customers. Every now and then I would go out back to take out trash. That was the extent of my employment.
On January 23rd, 2019, what time did your shift start?
It started around noon.
I'm sorry, Mr. Gilmore, I'm not sure I caught that.
It started around 12 p.m. noon.
Okay. You told us that you fell while you were at work. Where were you when you fell?
I was out back by the loading dock area.
I want to take a look at that loading dock. Ms. Furlani, can we get what's been admitted as Exhibit 2 on the screen? Mr. Gilmore, why were you back on this loading dock?
That was where we were required to take our smoke breaks.
Well, hang on. You said you were required to take your smoke breaks. Why were you smoking back here?
Well, whenever I needed to take wanted to take a smoke break, that's where where Chimes asked us to take our smoke breaks out there.
Well, I want to take a look at exactly what the defendant said. Can you open up Exhibit 1 on your computer?
Yes.
Let me know when you have it.
It's up.
What's Exhibit 1?
Exhibit 1 is a memorandum that Chimes sent to their employees.
Is that a fair and accurate copy of that memorandum?
Yes.
Plaintiff offers Exhibit 1 into evidence.
Defense?
No objections, Your Honor.
It is admitted.
Ms. Furlani, can we get Exhibit 1 up? Mr. Gilmore, we see this email is from someone named Lane Kim. Who is that?
Lane Kim is one of the managers. She was the manager the night my accident happened.
Who is this email sent to?
This was sent to all employees.
And what date was this email sent?
The date is July 1st, 2015.
Now, in this email, the defendant says the last time Reese came by the store, someone was smoking out front. We can't have that. Who's Reese?
I believe the owner of Chimes.
In this memo, the defendant said, as you have been told before, if you're going to smoke, you need to smoke out behind the store where our dumpster is. That is the only place you should take smoke breaks on the premises. Ms. Furlani, can we get Exhibit 2 up again? Is this that same loading dock and dumpster that we just talked about in the memorandum?
Yes.
The same loading dock where you fell?
Yes.
We talked a little about where you fell. I want to talk about how it happened. When you fell, was it daytime or was it nighttime?
It was nighttime.
Around what time did it happen?
I took my break around 7 p.m. So around 7 p.m.
How dark was it when you took that break?
It was pitch black.
When you went out back to take that break, did you go alone or with anybody else?
No, I went with one of my coworkers at the time, Riley.
Ms. Furlani, one more time. Let's get Exhibit 2 up there. Ms. Furlani's highlighting the platform here on the loading dock. Is that where you were smoking?
No,
Well, where were you smoking?
I was smoking down below because I didn't want the smoke to get back inside the store.
Down below. Is that about where Ms. Furlani just put an arrow?
Around, yes.
Well, when you fell, were you going down the stairs or coming back up?
I was coming back up the stairs.
I want the jury to see what it looked like for you coming back up those stairs. Ms. Furlani, can we get what's been admitted as Exhibit 3 on the screen? Ms. Furlani is going to highlight the object on the right here. What is that?
That's the door to either get out or get back into Chimes.
When the door's in the way like this, how do you get up the steps?
You kind of walk up and then you kind of have to get around the door to get back in.
Do you know what these circles on the concrete are?
It looks like where a railing used to be.
Can you tell us how you fell off the steps?
So I was walking up those steps, and as I kind of put my foot on the top level there, I felt my foot slip a little bit, and instead of just letting myself fall back and potentially hit my head, I figured it'd be better to land on my feet. So I tried to jump back so I could land on my feet, but because the ground was pretty uneven, all of my weight ended up shifting to my right leg, and I essentially landed on my right leg, fell backwards onto my rear.
Mr. Gilmore, were you here for defense's opening statement?
Yes.
Do you remember when they said that it was your fault that you fell off of those steps?
Yes.
When you were going back up those steps, how careful were you being?
Just like any other time. I'm not.
Were you doing anything to steady yourself as you walked up the steps?
I had my hand on the wall.
Were you running up those steps?
No.
As you were walking up, were you scrolling on your phone?
No.
Ms. Furlani, can we get one more look at Exhibit 3? The concrete that we see on these steps. Do you know what happened to it?
No, not at all.
Do you know how it got like that?
No.
Mr. Gilmore, after you fell, did you get back inside the store?
Yeah, Riley helped me get up and I ended up going back into the store.
You told us about Lane Kim, the manager. Was she there that night?
Lane Kim was there that night, yes.
Did you talk to the manager?
Yeah, I basically gave her a report of what happened out back when I got back in.
When you told the defendant's manager about how you fell, what did the defendant say?
Lane basically said that they should have fixed the stairs a long time ago. She reported it to upper level, but there was always something bigger to fix at the time.
Thank you, Mr. Gilmore. Pass the witness.
Cross.
Yes, Your Honor. First off, Mr. Gilmore, I want to say that I'm sorry we have to be here today and that you were injured. I know you and Chimes wish we were not in this position, and we want to say we sincerely recognize that. I do, however, have to ask you some questions, though, and if any point you can't hear me or you don't understand, please don't hesitate to ask me to repeat or rephrase a question, okay?
Okay.
I want to turn to something you mentioned during your direct examination. You told your lawyer that on the night in question, you were on a smoke break, correct?
Yes.
And Chimes had a policy that all employees needed to smoke out back by the loading dock.
Yes.
Now, they never told you to go on the loading dock for that, did they?
I don't believe so.
In fact, you discussed the memorandum to employees, Exhibit 1, with your lawyer on direct examination, right?
Yes.
Ms. Combs, if we could have that put up. Now, that memo says if you're going to smoke, you have to do it by the loading dock, right?
Yeah, well, behind the store where our dumpster is, that's by the loading dock.
It goes on to say you need to smoke out behind the store where the dumpsters are, and that is the only place you should take smoke breaks on the premises, correct?
Yes.
It doesn't mention the loading dock, does it?
No.
And it doesn't say that you can't smoke off premises.
No.
And it doesn't say you can't smoke in your car.
No.
I wanna circle back around and talk about your experience in working and dealing with that loading dock. At the time of the accident, you've been working at Chimes for about 10 years.
Yes.
In those 10 years, you went out by the dumpster and loading dock frequently.
Yes.
In fact, you'd guess that you probably were out there 20 times a week.
I'd say about yes.
And in the entire time that you were working there, there was never a rail on that loading dock, was there?
No.
And you never raised any complaints about any railing on the loading dock with your managers, did you?
No.
That's because it was a loading dock. You don't even think that you could put a railing on a loading dock.
I mean, not on a loading dock, but maybe stairs.
And you were never injured there until January 23rd, 2019.
Yes.
Now, I want to talk about the events that took place that night. That night, things were a little bit different than normal, right?
I guess.
It was pretty dark outside.
Yeah, it was dark outside.
But it's not always dark at 7 p.m. year-round in Waco.
That time of the year, it's pretty normal for it to be dark around 5:30, 6.
But here in Waco, it's not always dark around 7.
I mean, depending upon the time of the year, no.
And that night, it was pretty windy.
Yes.
And your friend doesn't normally hold the door like she was that night.
I don't believe so.
And you would also say that it was pretty cold.
Yeah, it was cold outside.
It's certainly not always cold in Waco, is it?
No, but I mean, it was winter, so. Yeah, it was
Now, you weren't planning on being outside very long.
no, just long enough to smoke a cigarette and get back in.
That's right. In your own words, it's just too cold to lollygag out there.
I mean, yeah.
So you were just going to try to get inside as quick as you could.
I mean, I was trying to get back inside, yeah.
And your friend kept the door propped open and there was light coming through that door.
I mean, yeah, there was light coming through, but she was also standing in the doorway. So it was kind of blocked by her a little bit as well.
Now, after you both went outside, you walked down the steps.
Yes.
And you could see those stairs where you were stepping generally, couldn't you?
Generally, yeah.
And then after you went down the steps, that's when you smoked your cigarette.
Yes.
And then you began to go back up the stairs.
Yes.
Now, I want to be clear. We're not talking about a huge staircase, right?
It was 5 or 6 steps.
Ms. Combs, could we get Exhibit 19 put up for us? Now, looking at that picture right there, it's got only 4 steps to get to the platform.
Yeah, and then you have to step up onto the platform. So
And when you were going up those stairs, your friend Riley was holding the door.
yes,
And that door swings out onto the platform.
yes,
So you had to go around it to the right.
yes.
Ms. Combs, can we get what has been pre-admitted as Exhibit 3 and 5 put up? And now, this door was open that night,
Yes.
and you didn't ask your friend to open the door all the way when you walked up the steps.
No.
And when you reached the platform, something happened, didn't it?
Yeah, I felt my foot slip.
You tried to go around the end of the door.
Yes.
And at that point in time, like you've already said, you felt your foot slipping.
Yes.
And after you felt your foot slipping, that's when you fell.
Yes.
And after you fell, your friend rushed down those stairs and helped you back inside.
Yes.
But this time, that door was completely open, flush against the wall, wasn't it?
I believe so, yes.
And this time, you and your friend were able to walk up those stairs and get inside without any problems.
Yeah.
No further questions at this time, Your Honor. I pass the witness.
Any further questions, counsel?
I do have a couple of questions, Your Honor. Very quickly, point of order. Exhibit 5 was displayed during cross-examination. I don't have that on my list as one of the exhibits that's been admitted. It's stipulated authentic. We don't have an objection to it going onto the record, but we just want to make sure the record's clear about what's happening here.
Yes, Your Honor. That's entirely my mistake. I'm sorry, Your Honor. Go.
Understanding what you're saying, counsel.
Your Honor, Exhibit 5 was displayed during cross-examination. That is not an exhibit.
You did not make an objection to it. You're absolutely correct. I've already noted that 5 was referenced, displayed to the jury, but no objection was made.
Right, and we don't have an objection, Your Honor. We just
So
want
what's the problem?
we just want to understand if it's going to be moved onto the record or not by defense.
Your Honor, I'm not offering it into evidence at this time. It was for demonstrative purposes.
That's fine, Your Honor.
Proceed.
Yes, Your Honor. Just a couple more questions. Ms. Furlani, can we get Exhibit 2 back up again? Mr. Gilmore, you were asked a little bit about where you could smoke behind this the store, and if you had to do it on the loading dock. What is that door we're looking at there?
That's the door to get in and out of Chimes.
Is there a way to get out behind the store without going off that loading dock?
I mean, if you walked all the way around, potentially, but the easiest way to get out there is through that door onto the loading dock.
Thank you, Mr. Gilmore. Pass the witness.
Anything further of this witness?
No, Your Honor, I do not have a recross.
The witness is excused. Call your next witness.
Yes, Your Honor. Plaintiff calls our next witness, Kelly Danes, by deposition. Ms. Danes is stipulated unavailable under Rule 804A, and the former testimony exception applies Rule 804B1. We're having Ms. Furlani send a highlighted copy of the deposition, the portions we intend to read to defense counsel. It should be appearing in the chat any second.
I've got it, Your Honor.
And may Ms. Furlani turn on her video to read the witness's answers?
Correct.
And Your Honor, can we assume that you've instructed the jury on what deposition testimony is?
That would be accurate.
Last thing, Your Honor, are we okay to display any exhibits that are referred to in this deposition? The ones that are referred to have already been admitted.
If they've been admitted, as we've discussed, you may use them during the examination.
Yes, Your Honor. Starting from page 2 of the deposition, line 6. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Danes.
Page 3, line 13. What do you do professionally?
I'm the president of Danes Engineering and LLC.
What does your company do?
We provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations. So basically, we help to investigate engineering issues in those fields throughout the United States, mostly connected to lawsuits like this one.
Page 5, line 14. All right, Kelly, I want to move on and talk about your work in this case. What did you review in coming to your opinions in this case?
I reviewed the depositions of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fall and took pictures of that area.
Page 6, line 14. Are exhibits 6 through 12 through 20, I'm sorry, are exhibits 16 through 21 fair and accurate depictions of how that area looked at the time of Jordan Gilmore's fall?
Yes. Well, it was dark when he fell, but other than that, this is the same area and how it looked.
What do those pictures show?
Well, as you can see, there are no railings on the steps up to that landing area, and there's no railing on the landing area itself. Plus, you can see where the railing used to go into the concrete and how the concrete around those areas is worn down and cracked. So you can see this is a pretty dangerous situation.
That concludes our reading from this deposition, Your Honor.
Anything from defense?
Yes, Your Honor. We would also read segments of this deposition onto the record.
You may proceed.
Yes, Your Honor. Ms. Combs, starting with page 2, line 13, what do you do professionally?
I'm the president of Danes Engineering LLC.
What does your company do?
So basically, we help to investigate engineering issues in those fields throughout the United States, mostly connected to lawsuits like this one.
Moving now to page 4, line 21, how did you get involved in this case?
I got a call from the firm representing the plaintiff, Jordan Gilmore. It's a firm I've done work for in the past, so this isn't the first time that I've consulted in one of their cases.
Moving now to line 1 of page 5, guess that means they liked what you did in those other cases.
What can I say? I'm good at what I do.
Kelly, I'm showing you what has been marked as Exhibit 15. Do you recognize this?
Yes, it is the invoice for the work that I've done so far on this case, which obviously doesn't include my time today or my time for testifying at trial if I have to do that.
And Ms. Combs, could we put up Exhibit 15? Perfect. Is Exhibit 15 a true and correct copy of the invoice for your work on this case up to this point?
Yes, it is.
Moving now down to page 9, starting at line 4. Do you know or have any opinion on who is responsible for the maintenance and repair of the steps behind the Chimes store?
No, that's not what I was asked to do. I assume it was Chimes, but that's just a guess.
Moving now to page 10, line 19. Do the OSHA regulations place any requirements on employees?
Yes, there is a general duty requirement in 29 USCS section 654B, which says that employees also have to comply with the OSHA standards and regulations and basically have to be responsible for their own actions.
Moving now down to page 14, line 12. Would you agree, or you would agree though, that this area was used by Chimes as a loading dock at times?
Yes, at times.
And guardrails around that loading dock would certainly inhibit Chimes' ability to use it as a loading dock?
Yes, it would make it difficult.
Can you point to any specific regulations or codes related to how or if employers or others must place guardrails around loading docks?
No, I'm not aware of anything like that.
No further questions at this time, Your Honor.
Anything further from the read?
No, Your Honor.
All right. Anything else from plaintiff?
No, Your Honor. Plaintiff rests.
Okay. Anything from the defense at this time?
Yes, Your Honor. We would move under Rule 50A of the Federal Rules of Civil Procedure for a judgment as a matter of law in a light most favorable to the non-moving party, that being the plaintiff in this situation, Your Honor. There is no evidence that's been provided that a reasonable jury could find for the plaintiff on several of the issues that have been presented in today's case. We have no information that Chimes Department Store knew or reasonably should have known about a danger. We've also heard that Chimes Department Store, we haven't heard any evidence that they failed to exercise ordinary care to protect Jordan Gilmore from danger by both failing to adequately warn Jordan or the conditions and failing to make the conditions reasonably safe, Your Honor. We've not heard any information about who was responsible for this space, who was actually the one who owned it, nothing like that.
Response?
Your Honor, first on the issue of who was in control of the space, we have heard that this was a space that was used by Chimes. They had their employees take smoke breaks there. We saw Exhibit 1, that memorandum where they were told specifically to use that space. We heard from plaintiff's witness, Jordan Gilmore, that they used that space to take out trash, to take smoke breaks, that he used it a number of times. Defense counsel, in fact, elicited testimony from Mr. Gilmore that he had used those steps on a number of occasions over his 10 years working there. And so to respond to the prima facie case that was brought, the motion attacking the prima facie case, viewing the evidence in light most favorable to us, a rational juror could find we've met our burden. We show that there was an unreasonably dangerous condition. We saw photos, Exhibit 2, Exhibit 3, that show the state of the concrete on those steps, how there were holes in it, how it was worn, how there were chunks of concrete missing. And we heard testimony from an expert witness, deposition testimony, that said the state of those steps was dangerous and that someone should have done something to repair them. We heard that the defendant should have known about those steps. They were theirs. Their employees were using it all the time. Their employees were informing the management about those steps. And we heard a statement from the manager of the defendant that after Mr. Gilmore was injured, when he reported his injuries, the manager said, yeah, we should have fixed those steps a long time ago. Based on all this evidence we presented, a rational jury could find we've met our burden.
Brief reply, if any.
Yes, Your Honor, briefly. Your Honor, all the testimony that was just elicited has nothing to do with who was actually in control of this space. And furthermore, Your Honor, we've yet to see any evidence that Chimes did anything to fail to warn or take actions in this space. The employees there had used those stairs for 10 years. And this employee in particular, the plaintiff, had used those stairs in the condition that they were in for 10 years. So there's no evidence in today's case that the actions or inactions of the plaintiff in any way contribute, or the inactions of the defendant, I'm sorry, Your Honor, in any way contributed to the injuries of the plaintiff in today's case.
Your motion is denied. We will proceed with the case in chief of defendant. We will take a 5-minute break.
Yes, Your Honor.
All right, counsel. My calculations on presentation at this point in time is plaintiff has 29 minutes remaining and defense has 33 minutes remaining. With that, we will proceed with case in chief of defense.
Yes, Your Honor. The defense calls Miss Geller to the stand.
Having been previously sworn, you may proceed.
Good afternoon, Miss Geller. Would you please introduce yourself to the members of our jury?
Hi, I am Reese Geller.
And where do you live, Miss Geller?
I live right here in Waco.
And what do you do for a living?
I am the owner of Chimes Department Store.
What's Chimes?
Chimes is like a local department store here in Waco. It's kind of similar to like a JCPenney's. We sell clothes, things for your house, just really a little bit of everything.
And how long have you worked at Chimes?
Gosh, ever since I graduated from Baylor back in 1998, it's a family business. So,
Ms. Geller, have you been here throughout today's testimony?
yes, I have.
So you know why we're here today?
Yes, I do. Yes.
We've heard a lot today about the loading dock. So could you explain to the jury what that dock was used for?
Sure, yeah. So when our suppliers ship out products to us, we use the loading dock to drop off everything so that we can just easily transfer things from the truck inside to the store for the customers.
How many times a week do you receive deliveries?
Oh gosh, every day or close to it.
We've also heard a lot about that, how that loading dock doesn't have a railing. Why is that?
Well, because it's a loading dock, it really wouldn't serve its purpose if it had a railing. The point is so that we can offload things, and if there was a rail, it just wouldn't make a whole lot of sense.
Now, have you ever been told that loading dock is required to have a railing?
No, we haven't.
Do you know if that loading dock was used for anything else?
No, I mean, its primary purpose was just for unloading goods into the store, like I said. I do know that employees took smoke breaks back there. And then we also had trash back there, but its primary purpose obviously was to offload goods.
Now, you mentioned your employees would take smoke breaks back there. Why was that?
Yeah, so we had a policy, or we have a policy in place that if the employees choose to smoke and they're going to do it on the premises, we would prefer for them to do it out back. I mean, obviously, we're a family business. We don't want them doing that in the front. And so, yeah, we would, if they're going to be on the premises, we wanted them to be out back.
Was there anywhere else your employees could go to smoke?
Sure. Yeah, they could take a walk down the street, go get in their car. I mean, yeah, it was just the out back was just an option. Like I said, if they didn't want to go super far.
You also mentioned that your employees would use the loading dock to take out trash. Why was that?
Because that's where our dumpster was back there.
Based upon what you know about what happened to Jordan Gilmore, was he taking out trash when he fell?
No, from my understanding, he was on a smoke break during that accident.
Since you've been here today, you've heard Jordan's testimony.
Mm-hmm.
Do you agree that you're responsible for his fall?
No. I don't understand. I mean, when he was telling the story, why he, tried to shimmy around the door like that. It didn't make a whole lot of sense to me. And I just, they could have opened the door all the way, and I just don't understand why it had to happen.
Your Honor, I have no further questions at this time for this witness, and I pass the witness.
Cross?
Yes, Your Honor. Good afternoon, Ms. Geller. I want to start by talking a little bit about what you know. Ms. Furlani, can we get Exhibit 2 back on the screen? This is the loading dock for your store.
Yes, it is.
It's the loading dock where Mr. Gilmore fell.
Yes.
The loading dock where he got hurt.
Yes.
Now, you're a smart businesswoman.
Thank you.
You've been a business owner for more than 10 years.
Yes.
You knew that employees were going to be using this loading dock,
Yes, I know that. Yeah,
bringing products into your store,
correct.
taking smoke breaks,
Yes.
taking trash out to the dumpster,
Yes.
holding garbage bags,
Yes.
carrying boxes.
Yes.
You didn't want anyone to fall on this loading dock.
No.
You didn't want anyone to get hurt.
No.
Let's talk about whether you knew that these steps were dangerous before Mr. Gilmore's accident. Can you open up Exhibit 14 and let me know when you're there?
Mhm. Give me just a second.
Take your time.
Okay, I have it, I believe. Yes, I do. Yes.
Okay. Exhibit 14, that's a report from one of your employees about an accident.
Yes.
An accident on that same loading dock.
Yes.
It's a fair and accurate copy.
Yes.
Plaintiff offers Exhibit 14 into evidence.
Vince?
Yes, Your Honor. I would object to hearsay, although there is a segment of this document at the very end that has a caption above it that says for Chime's use only. Every single other part of this document is from a third party, someone by the name of Jason Stiles. We don't have an opportunity to cross-examine that person today, and therefore every other part of this exhibit except for that final bit would be hearsay, Your Honor.
If I can respond, Your Honor.
Let me make sure I understand what this document is. It is a January 12th, 2010 recorded statement.
Yes, Your Honor, from an employee of the defendant made to a manager of the defendant and then reported to the company.
All right, sir.
Yes, Your Honor. This exhibit is actually exempt from the rule against hearsay under Rule 801D2. The statements contained in that report, they're statements of our party opponent, of an agent or employee made within the scope of that employment.
Wait a minute. You told me it was an employee. Is it a managerial individual that has authority for hiring and firing?
So there's two things happening here, Your Honor. There's an employee who's making statements to a manager, and then that manager is reporting it out. So there's sort of a potential hearsay within hearsay issue here. I can tackle both of those layers, though.
You need to tackle them.
Yes, Your Honor. The report itself, that satisfies Rule 801D2. It's a statement by our party opponent made by a manager who has that.
You keep saying the report. It's a recorded statement.
Well, Your Honor, it is a report. There's portions of the report that, one, it gets reported out to the company itself. Two, there's statements made by the manager within that report on the very last page. And the statements from the employee, we believe, one, satisfy Rule 801D2. But even if they don't, this is being offered not for the truth, but for notice and knowledge that the defendant company would have had about those steps. In that report, the employee says they slipped on those steps, and that's why they fell. So it goes to their knowledge, their awareness of the dangers of those steps.
Defense?
Yes, Your Honor. Tackling those arguments one at a time, this is recorded statement, like Your Honor mentioned. The only part of this statement that was ever an opposing party statement or a statement made by the Chimes managerial staff is the last section on page 3. The rest of this document comes from this Jason Stiles individual. All the information that's provided here is about that Jason Stiles individual who, although was an employee at the time, was not in a managerial position. Second, Your Honor, in taking the second argument that opposing counsel made, this document here was not used in any sort of business capacity. We have no evidence on the record to suggest that this evidence was ever passed up the managerial chain. We have no evidence on the record to suggest that this was a regularly conducted business activity or anything of that matter.
I'm going to admit it with an instruction to the ladies and gentlemen of the jury that it is being admitted for the limited purpose of notice to the defendant. You may proceed.
Yes, Your Honor, we'll only use it for that purpose. Ms. Frulani, can we get Exhibit 14 on the screen? Ms. Geller, this is a report from 2010. I'm sorry, I couldn't quite hear you. Is that a yes?
Yes.
One of your employees reported that they slipped and they fell.
Yes.
They said they slipped on loose concrete.
That's what they said. Yes.
Your Honor, I would re-raise my objection at this time. Opposing counsel is asking about the truth contained in these statements.
Sustained.
Yes, Your Honor, I'll ask questions that relate to knowledge.
Correct.
Ms. Geller, you got this report, right?
Yes.
After you got this report, you didn't go and repair those steps?
No.
You didn't have the concrete fixed?
No.
You didn't replace the chunks of concrete that were missing?
No.
You didn't instruct your managers to make sure employees stay off the loading dock unless they're loading packages?
No.
You didn't tell the employees, unless they're loading packages, keep off the loading dock?
No.
I want to talk a little bit more about how this specific accident happened. Now, you know, on January 23rd, 2019, Jordan Gilmore fell off your loading dock.
Yes.
Ms. Filani, can we get Exhibit 3 back on the screen? This is what that loading dock looked like.
Yes.
It's what it looked like in 2019.
Yes.
We can see here, there's still holes in the concrete.
Yes.
There are still places where the concrete's loose.
On the very edge, yes.
Places where chunks of concrete are missing.
On the very edge, yes.
You told us a little bit ago you were here for opening statements.
Yes.
You remember when your attorney talked about how the why was important in this case?
Yes.
I want to talk about why these steps still look like this in 2019. You started leasing this property in 2005.
Yes, that's correct.
From the time you started leasing the property until Mr. Gilmore's injury in 2019, those 14 years, you didn't make any repairs to these steps.
No, I didn't see the need to.
Not asking if you thought you needed to, just asking if you did, you didn't.
No.
In those 14 years, didn't fix any of the concrete here.
That is correct.
You know that on January 23rd, Mr. Gilmore was out back about 7 p.m. at night.
Yes.
Just like what happened in 2010.
Yes.
You know, Mr. Gilmore, he was walking on the steps.
Yes.
He slipped on the steps.
He fell trying to go around the door. Yes.
He lost his balance on the top step.
Yes.
And he fell.
Yes.
And he got hurt.
Correct.
Just like back in 2010.
Correct.
Thank you, Ms. Geller. Pass the witness.
Redirect.
Briefly, Your Honor. Now, Ms. Geller, was Chimes Department Store under the impression that it was in compliance with regulations?
Yes. Yeah, we were.
Have you ever received a citation from OSHA?
No.
Have you ever been made aware from an OSHA representative that there were any problems with the stairs in the back of your facility?
No. They actually came out to the location a couple months before this and checked it out, and they said we were fine.
No further questions at this time, Your Honor.
Anything else of this witness?
Not from the plaintiff, Your Honor.
This witness is excused. Call your next witness.
Yes, Your Honor. At this time, plaintiff calls by deposition Perry Hayden.
And
Second, get the microphone set up here, Your Honor.
Once you get set up, you may proceed.
Yes, Your Honor. Starting on page 2, line 5. Can you please state your name for the record?
My name is Perry Hayden.
Moving down to line 11, what do you do for a living?
I'm a compliance safety and health officer with the Occupational Safety and Health Administration.
Moving now to page 5, starting at line 6. All right, Ms. Hayden, how are you involved in this case?
Well, I conducted an inspection at the Chimes department store in Waco back in 2018.
Moving now to page 6, starting at line 8. Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Moving now to page 7, starting at line 13.
The manager told me that there used to be guardrails, but they were removed because Chimes used that landing area as a loading dock.
And now to line 16. Why does that matter?
Because loading docks don't have to have guardrails.
How do you know that?
Because OSHA says so.
Moving now to page 8 at line 20. Is there any OSHA regulations that does specifically discuss loading docks?
Yes. 1910 section 28B1 III clearly states that guardrails aren't required on loading docks because they aren't feasible. You can't very well load something onto the dock with a bar in your way.
Moving now to page 9, line 12. Was this area behind the store exclusively used as a loading dock?
No, it was my understanding that employees also went out there to throw trash in the dumpster and to take breaks. And it is certainly possible that employees went out there and did other things as well, but I don't think that matters.
Why not?
Well, just because an employee goes out and sits on the edge of a loading dock and eats a sandwich doesn't make that loading dock a diner. The key here is that Chimes use this area as a loading dock. That's what matters.
No further questions at this time, Your Honor.
Anything from plaintiff?
We do have a couple portions we want to read in, Your Honor.
Then proceed.
Starting from page 6, line 22. Question. When you went out there, what did you notice about the steps and that landing area? Answer. Well, at first, I was a bit alarmed because there were some pretty obvious issues. Question. Like what? Answer. Well, there were stairs and a landing area where there were no guardrails anymore. Plus, the concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems. And that's all from us, Your Honor.
All right. Anything else from this proffer from the defense?
No, Your Honor.
Call your next witness.
Your Honor, that concludes the defense's case in chief.
All right. Do we have any matters?
Yes, Your Honor, we would re-raise our motion under Rule 50B of the Federal Rules of Civil Procedure. Again, at this time, Your Honor, we've heard no evidence as to the why Jordan, the plaintiff, fell off the railing that day. We've seen a number of different witnesses come before us today. We've heard from a number of different witnesses that there was no OSHA violation. There was no OSHA citation. There was nothing wrong with that platform. And in the 10 years that the plaintiff worked there, the only time that he fell was when he was doing something different than he had ever done it before. And in a light most favorable to the non-moving party, Your Honor, no reasonable jury could find for the plaintiff in today's case.
Plaintiff?
Yes, Your Honor. Similar arguments to what we had a little bit ago. We have put evidence on from an expert witness that said that the steps, the way the concrete was, they were unreasonably dangerous. And we just heard actually from the defense's expert witness when we read in portions of their deposition that when they looked at the steps, when they looked at the concrete that was eroding and the cracks, it seemed pretty obvious that something was wrong with those steps and that they created danger. So we certainly put evidence of a dangerous condition on. As to the causal part, we've heard that Mr. Gilmore put his foot on that landing and he lost his footing. A rational juror, viewing the evidence in light most favorable to us, can hear that evidence. and conclude that he lost his footing because of the concrete. We've certainly presented enough evidence that defendant's motion should be denied.
That motion will be denied, and we will proceed to closing argument. We will take a brief moment so that you all can collect your thoughts and be prepared. How much time do you need?
Your Honor, I'd be happy with anywhere from 5 to 10 minutes. Mr. Messino.
Fine with us, Your Honor.
We run a tight ship here, folks. 5 minutes.
Yes, Your Honor.
All right. Thank you. Council, on the time, I show remaining for plaintiff 18 minutes, remaining for defense 24 minutes. Does plaintiff want a warning?
I don't think I'm going to get close to time, Your Honor. I think we're okay, but thank you.
And that is for closing and rebuttal. For defense on closing, do you need any warning?
Your Honor, if I need a warning, you can go ahead and take me out back because I do not intend to use 24 minutes.
All that are jurors appreciate that greatly from both of you. And with that, we will proceed with closing arguments. Plaintiff, you may proceed.
Your Honor, in addition to admitted exhibits, may we also display some portions of the jury charge during closing argument?
Both parties may.
Thank you, Your Honor. May it please the court.
You may proceed.
An employee is standing on top of the defendant's loading dock. He takes a step forward. A step where there's a hole in the concrete. Where the concrete is loose. Where the step is broken. The employee, he slips. He loses his footing and he falls. He's hurt. Members of the jury, that's the story of Jordan Gilmore in January 2019. But the evidence you heard today is that the defendant knew about that way back in January of 2010. And they didn't fix the steps. They didn't fix the concrete. Not in 2010, not in 2011, not ever. The worst part about the defendant's decision to maintain their steps poorly is that the injuries to Jordan Gilmore are permanent. And the evidence has shown the defendant, they're responsible for those injuries because it was their dock, their steps, and their fault. Of course, it wasn't good enough for us to just tell you the defendant's responsible. We had to prove it. And we had to prove it by a preponderance of the evidence. And we've met that burden by proving those three facts that we mentioned in opening statement. Let's take them one at a time. Fact one, there was a dangerous condition. As the judge will explain, we had to prove there was a condition on the defendant's property that created a substantial risk of harm. Today, we saw the loading dock on that property. And we saw the steps on that loading dock. How those steps were jagged, weathered, worn, cracked, whatever word you want to use. It's what happened here. Chunks of concrete that had been missing for years. And we heard testimony from our expert witness, a professional engineer, who told you the same thing. Yeah, these steps, they were dangerous. They needed to be fixed. And even the defendant's own expert said the same thing. Remember when we read that portion from her deposition? She said, and I quote, "The concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems." what was the defense's response to all that? They didn't want to talk about concrete. They wanted to talk about everything else. The railing, why the employees were back there in the first place. Did the word concrete even come out of defense counsel's mouth once throughout this trial? The reason the defense ignored the concrete, ignored the cracks in the steps, ignored those photographs that we showed you, is because they know there is no answer. They know that those steps, they were dangerous. They created a substantial risk of harm. Brings to the second fact we had to prove. The defendant didn't fix those steps. As the judge will explain, we had to prove that the defendant failed to act like an ordinary store. They failed to exercise reasonable caution an ordinary store would under the similar circumstances. So what would a reasonable store do in these circumstances? Well, they would do something. But what did we hear the defendant did after 2010, when that person, their employee, slipped on the steps, on the loose concrete, and they were told about it? What did they do?
Objection, Your Honor, as to that segment right there. We already had a ruling on that, and I would move to strike that segment of the closing, Your Honor.
But what is your response to that, counsel?
Your Honor, the way I'm phrasing the argument now is going directly to the knowledge defendant company had about that specific instance, how it relates to the danger of those steps.
I think you're being very, very, well, you're running close to that line, and I'm going to instruct the jury again that that piece of evidence was limited to the issue of knowledge of a condition. No more, no less. Proceed on that basis, your counsel.
Yes, Your Honor. We heard when we cross-examined the defendant's owner, we asked her, after you leased this property in 2005, did you ever repair any of those steps? She said no. Didn't have a single record from any repair. Didn't even seem to think that they needed to make any repairs. And remember, this was their dock, their steps, their employees that were going out there every day for their smoke breaks, to make deliveries, to take out the trash. And with their employees walking up and down those stairs every day with the concrete looking like that, the defendant decided, we don't have to do anything. Brings us to that last fact we had to prove. The dangerous condition caused Jordan Gilmore's injuries. As the judge will explain, causation, it has two parts. We had to prove that the defendant's negligence was a substantial factor in causing Jordan Gilmore's injuries. We heard from Jordan Gilmore that he stepped onto the landing where there was a hole in the concrete, where the concrete was worn away. How he lost his footing, and he fell and he got hurt. Of course, the condition of the steps was a substantial factor. We also had to prove that it was foreseeable. That it was foreseeable that given the nature of those steps, that someone would get hurt. Members of the jury, if you have steps with a hole in them, steps where the concrete is broken off, steps where there are cracks everywhere, it's foreseeable. Yeah, someone's going to lose their footing. Someone is going to get hurt. This is the jury verdict form. Because we've proven those three facts, because we've met our burden, because it was their dock and their steps, we've proved it was their fault. And you can write yes next to the defendant. But there's still more we need to talk about before you finish that form. Because defense, when there were railings and everything else, when that didn't work, they tried to blame Jordan Gilmore. They said, it's not on us, not on the way we maintain those steps. It's on Jordan, the way he walked up them. Members of the jury, we heard from Mr. Gilmore. As he was walking up those steps, he was being careful. He wasn't running. He was holding on to the wall. And he was being careful because he couldn't see what was in front of him, because it was pitch black. Defendant says, it's Jordan who's responsible for these dangers? No. It was their doc. They're the ones who are responsible. In a moment, defense counsel is going to come up and they'll continue to try and make excuses. And when they do that, I want you to remember what you heard that the defendant's manager said to Mr. Gilmore after he fell. The defendant's manager said, yeah, we should have fixed those stairs a long time ago. In their opening statement, defense counsel talked a lot about the why, how the why was going to be so important in this case. They've said it a couple times now. Well, if you're looking for a why this injury happened, it's right there. Yeah, we should have fixed those stairs a long time ago. Those were their stairs on their dock. And because of that, it was their fault. We ask that you hold the defendant responsible. Thank you.
Defense?
Yes, Your Honor. May it please the court.
Yes.
Your Honor, opposing counsel, members of the jury. Accidents happen. When you make a mistake, it doesn't mean that someone else is to blame. That's what we've heard throughout today's testimony. We've heard how on that cold January night, the plaintiff did something different than he normally does. He tried to squeeze between the edge of the door and the end of that loading dock. And it was at that moment when he was squeezing between that 1 foot gap that he fell. You see, the plaintiff, he'd been working at Chimes department store for over 10 years. And on that January evening, he was taking his last smoke break before the end of his shift. He walked outside, he had a cigarette. There's no time to dilly-dally around, it's cold out here. So he walks back up the steps, but unlike every other time, when the door behind the building is flush with the wall, this time, the plaintiff's friend is holding that door so that only a foot is left between the end of that door and the edge of that 3-foot platform. Members of the jury, that's why you're here today. No one throughout today's trial has disputed, and we certainly don't do it now, that what happened to the plaintiff is unfortunate. And we wish that we weren't here today, just as much as I'm sure the plaintiff does. But members of the jury, it was the plaintiff's job today to prove to you not only that there was a duty and a breach of that duty, but that the actions or inactions of the defendant were the cause of the plaintiff's injuries. Members of the jury, they had to prove that to you by a preponderance of the evidence today. So let's walk through what we've heard today. Let's take a look at some of those exhibits, read some of those memorandums, and by the time I'm done, and Judge O'Neill has charged you as the members of the jury, I'm sure you'll agree. When accidents happen, when you make a mistake, it doesn't mean you can blame somebody else. The plaintiff contends today, and you heard just a moment ago that they believe that Chimes department store, that they're negligent today. Members of the jury, you've heard from multiple witnesses today. The Chimes department store didn't violate OSHA, and they didn't violate the International Business Code. Whenever that building code was put into place, it's meant to protect people. So let's talk about that loading dock and the concrete on those stairs that plaintiff's counsel wants to talk to you about. And unlike what he said, we're not afraid to talk about that concrete. You see, that concrete had been that way for over a decade. The entire time that the plaintiff worked at Chimes department store, that concrete was exactly the way it had always been. You heard when Ms. Geller took up the stand today, she told you that only the edges of that platform and of that loading dock were in any way damaged. And that they had been that way since Chimes moved into that space in 2005. But the only time that the plaintiff was injured was when he did something that he doesn't normally do. Now, hearing plaintiff's counsel talk about it, you might assume that an employee doesn't have a duty to look out for their own safety in the workplace. The members of the jury, you've heard from the plaintiff's own witness, Kelly Danes, that in fact, employees have an obligation to look out for their own safety as well. And that means when an accident happens, and it's the choices of that person that caused that accident, they don't get to blame somebody else. Not only that, members of the jury, you've also heard today that when an OSHA representative, a person in charge of making sure that businesses are protecting their employees, went out and saw that loading dock, he was concerned. Up until he learned that it was a loading dock. You've heard throughout today's testimony, and when we called by deposition that OSHA agent, you heard that Perry Hayden, he told you that the law that applies to a loading dock is different than the law that applies to an elevated platform. Members of the jury, they want you to believe that an elevated platform, which is a stage, that's what that was where the plaintiff was injured. But the plaintiff himself told you today that that was a loading dock. And every other witness you've heard from today, except for the one that the plaintiff is paying $750 an hour to be here, has told you that that was a loading dock. The plaintiff himself said it. Members of the jury, that's not the only thing you've heard today. You've also heard that it wasn't Chimes that caused the injury. You've heard that that fall happened because on that day, on that cold January evening, the plaintiff did something that he hadn't done before. He tried to squeeze between that 1 foot gap. He tried to squeeze between that small gap at the end of the door and the edge of that platform. He didn't tell you that the concrete gave out from underneath him. He didn't tell you that it was because it was dark. In fact, he said that the platform was illuminated and that when he was going down the stairs, he could generally see where he was going. And you all saw today that door was open, light spilling out of the back of Chimes department store. The platform was illuminated. And that is where the plaintiff fell. Not on the way up the stairs, it was when his right foot reached the top of that platform as he was squeezing around the end of the door. Those were the choices of the plaintiff today. Those are the choices that he decided to make. You see, as unfortunate as it might be, the plaintiff caused his own injuries today. We wouldn't be here if not for the fact that the plaintiff did something different. So in a few moments, when you go back into the jury room and Judge O'Neill charges you with the law in today's case, you're going to be asked about proximate cause. And proximate cause simply means that the person who is responsible, the why, of why you're here today and why the plaintiff was injured was because of the plaintiff's own actions. And after Judge O'Neill is done charging you, you're going to get to see a jury verdict form. And that verdict form is going to look exactly like this. And I'm confident that when you go back through and review the evidence and see just how small of a gap the plaintiff was squeezing through, when you're able to read his testimony about no time to lollygag outside, got to get back inside, it's cold. He also told you that he did something different that day. Because of that, we're confident that you'll return a verdict of not liable for Chimes department store. And as unfortunate as it may be, when accidents happen, you can't blame your mistakes on someone else, members of the jury. And that's why you'll be able to mark yes next to Jordan Gilmore. You can't blame somebody else for your own mistakes. Thank you.
Rebuttal?
Yes, Your Honor. Defense just spent a lot of time in their closing argument trying to convince you that that photo we've been seeing all day, it's a photo of a loading dock. And yeah, we agree. This is a loading dock. It's a loading dock with steps that were dangerous, that were damaged. See, when defense counsel just had the opportunity to defend the concrete on these steps, the only thing they came up with was, well, people have gone up and down them a lot. And that might be convincing if it weren't for the words of the defendant's manager when she learned about Mr. Gilmore's fall. Because when she learned about it, she wasn't surprised. She didn't say, huh, that's strange, you fell on the steps? Remember, she said, yeah, we should have fixed those stairs a long time ago. The defendant knew that the concrete on these steps was dangerous. And it was a matter of time before someone got hurt. Before someone got hurt on their dock, on their steps, when it would be their fault. I ask that you find them responsible. Thank you.
Matter will now be submitted to the jury. This concludes the case. Well, you guys did a phenomenal job. Let's take a 3-minute break while the scoring judges and others work on their ballots, and then we will circle back. All right, I would invite our scoring judges to come on board. As you probably folks the contestants have been told, we have been asked to be very specific in our comments, short in our comments, such that to give you thought and aid for the next round. So let's start. Who wants to go for first? Any volunteers? I volunteered you last time, James, so here you go. Here you go, my friend.
Sounds good. Happy to do that. I'll do the obligatory but true, really good job. You guys did a great job, and I actually don't always say that. You both really did. I'll try to focus on just a couple of comments that help you move forward, and rather than substantive stuff. You guys always know the case file better than we do, so it always bugged me when I would get a bunch of substantive. Did you ever think about this theory? That wasn't in the case packet. You can't do that. Let's see. Got to be careful with, so on your closing, Mr. Nacino, if you get an adverse ruling or a limiting instruction, the only thing you can do to make it worse is get too close to the line and make the judge spank you twice, and undoubtedly more forcefully the second time. So I wasn't listening particularly carefully to how far you crossed the line, but the judge just said you did, and he wore the black robe. So, you know, I think you were flirting with it, but you got too close. So that's a big thing, and it's at closing, which hurts. And then Mr. Hobbs, two things, and you did it really well in opening. I thought you did a really good job of sympathizing with the plaintiff while blaming him at the same time. Then whatever impulse caused you to do a really good job about that caused you to, in my opinion, cross the line of vouching in your cross, where you opened the entire cross up with, boy, I'm really sorry you have to be here. My company's sorry you have to be here. We're all sorry you got hurt. A, you can't do that. B, it's really probably not real smart to do that, because in your opening and your closing, you had done what that comment was intended to accomplish. By being a sympathetic character, you're very happy and smiley, and that's wonderful. And I do that a lot myself. But you've also got to watch that you don't go over the line trying to be likable. So there's my comments. Again, you guys did a really, really nice job. It was fun to watch.
Scott?
Sure. Agree. Think you both did a great job. I think you'll find when you get into practice that these things are a lot more similar to actual trials than you might believe. And it's good experience, and you'll be comfortable when you do have your first rodeo. No real advice for you. Anything I'd give you is not even worth a cup of coffee, but I would say just two things. I always kind of have a pet peeve, and I was probably guilty of it back then too. If you ever listen to reporters talk on TV, they have like a reporter speak and the way they sound. People do it in mock trial too. Excuse me. They use some of the same cliches and they say the same words or the same things. Just try to be more casual, more present, and actually speaking to the jury, and just try to sound more normal. And the other thing I would say is, I'm not a huge fan, and I tried not to do it when I was in mock trial. All the housekeeping stuff and all the pointing out of things, just kind of grab control of the trial and get to it. No judge is going to stop you and be like, well, counsel, did you consider whether I should have, constructively given an instruction to this jury? They should move on and get to the next question. So just kind of blow through it and focus on content and style. But you guys did a great job. Best of luck in the future. And you both, I think, are pretty talented guys. So you'll do well in this tournament.
Warren?
Hey guys, great job. I'm going to echo everything that, Scott and James said. My, advice for Mr. Nacino, the objection about the exhibit that Mr. Hobbs did admit. Object when it's happening on a competition level. Don't object once it's already done. I understand that it didn't hurt you and you didn't really have an objection to what he was, trying or forgot to admit. But at least if you object when it's happening or as soon as he's done and he doesn't offer it, you're letting that judge know, even if you didn't have objection, just maybe have an objection, because it's like, hey, he missed this. In a reality, obviously in real life trials, if it's not hurting you, don't bring it up. Juries, are going to get annoyed with it. If it's a bench trial, the judge is going to get annoyed that you're bringing it up, and you know, it doesn't matter in the end. But otherwise, excellent, excellent. You did a great job. Mr. Hobbs, the only suggestion I have for you is, I've been there, man. I used to try high-level felony cases in criminal court, and you just forget sometimes. The adrenaline is going, you forget to offer an exhibit, or you forget to offer it as a demonstrative. You know, use a checklist. I'm a big fan of checklists. I used to teach, so I make sure that I still have my elements even when I'm in trial now with lawyers trying cases in front of me. I still have my elements checklist, especially if it's a bench trial, because I'm checking them off as we go. I'm checking off and making lists of exhibits. The competition, the judges know if you miss it, but in real life, juries and judges may not know, depending on how close of attention the judge is paying. But otherwise, great job. You all really had a great grasp on the material, and I wish you well in the further competition.
I echo everything folks have said, had many of the same comments, so I'll be even quicker. When you proffer, Mr. Nacino, I think it's better to have your co-counsel do it, even if it's brief, because I've been told by jurors that when I do question answer, because I'm just trying to get through it, they lose who's saying what. So I would certainly say that. There is some strategies. Obviously, we know, you guys made certain decisions about the responsible third party. So, it is what it is. But be thinking about that. From the defense, with that offer of the recorded statement, and by the way, Mr. Nacino, a report is not a recorded statement. A recorded statement is not a report. I mean, I'm an insurance defense lawyer, and so, I live with that all the time. But the other side of that was, were they not trying to introduce a prior bad act to show some sort of note? I mean, you have to be prepared to not only say what the heck's going on, because do we really hear that the means by which the first fall was same or similar to this guy's fall? And I never heard anything discussed about that. And so with that in mind, it's like, I'm gonna let the jury figure it out. And so think about that as you go along. And the last thing I would say for both of you, you guys use the demonstrative exhibits extremely well. But one thing, if you could put the two pictures, one with the door shut, showing the full area coming up the stairs that the person could have walked with, and then the second picture showing just the little sliver, of space. Yeah, and then you're going to use it, Mr. Nacino, to show the broken. I mean, it is what it is. They have the door coming out that way. It is what it is. I think it'd be very effective to have those two pictures next to each other. Really good job. Okay. Anybody else got anything? All right.
I just wanted to thank you all for being here today. Really appreciate it. It's been a lot of fun.
Great. Good.
Mr. Nacino, I got one more for you.
Sure.
You authenticated an exhibit as a fair and accurate copy. There's no such thing. It's either a true and correct copy, or it's something that fairly and accurately depicts like a photo. So if it's depicting something, it's got to be a fair and accurate depiction. If it's a copy of something that doesn't depict anything, it's just words, and it's a true and correct copy.
Okay.
Mock trial world more than real world. Realistically, judge is going to let you do it, but for this purpose, get them right.
Appreciate it.
Yep.
And I'll tell you, in state court in the 170th, all the exhibits, and judge knows this, all this would have been taken care of pre-trial with the exhibits. I mean, we don't ever get into this anymore, so it's all pre-trial. Great job. We get to go home and have dinner and get ready for having a nice evening. You guys get to go work and get ready for tomorrow. Welcome to the practice of law. All right, everybody take care. Bye-bye.
Have a good one.
Because it wasn't plugged into anything. Hey, are you still up at the office? Okay. Okay. Well, have a nice week.